considering the prayer. The matter stands adjourned for 3 weeks. Oblige. Respondents to file their counter affidavit in the meantime. Oblige. Okay.
If I may, my lord.
Yes.
My lord, I beg to mention item number 13, my lord.
Number
13, my lord. 13.
13.
Yes, my lord. It has been wrongly listed in the admission hearing column, my lord. It is supposed to be fixed for order. It has already been admitted, and we have furnished extra copies to the respondent, my lord. It's for them to file affidavit in opposition, my lord.
Okay. Your good name?
Mukbang Pertin, my lord.
Mr. Mukbang Pertin, learned counsel for the petitioner, submits that the matter has been wrongly listed in the admission column as the case has already been admitted earlier. Stop. He, however, submits that the respondents are required to file their counter affidavit.
Yes. 3 weeks time may be given. 3 weeks.
That's prayed for by the learned counsels appearing for the respondents. Further 3 weeks time is granted to file counter affidavit. List again after 3 weeks in the orders column.
Much obliged.
May I make mention, my lord? My lord, I want to make a mention of 2023 case, long pending case, my lord. This is in the hearing stage. May I pray for list that matter tomorrow?
Tomorrow not possible.
Then on Monday, on 16th, my lord.
16. Do you have any discount? Do you maintain any diary or any list that how many matters are next week like that?
We have I take matters after. Because people we can put some.
No, that's okay. Date so we can. What I'm saying is that do you have any diary maintained so that you know, or like? No, you maintain also. You have one diary, okay? You have one diary. Normal diary you can have. Just take a note. How many matters can this? Supposing they'll come and make a report. Like next month 15, they want 1 case. You know, 1 case. If tomorrow somebody may say 15 1 case, then you know 1 case. After 1 week, somebody mentioned it for 15, then you know that there's already 2 cases. You can inform the court. There's already 2 cases. There are at least 5 cases like that. So that all the cases don't get jumbled in 1 day. Just try to maintain a diary. It will be very good.
My lord, if it is not possible for Monday, let the matter list on
We have
16th.
2 cases already. So you can have it on perhaps on Tuesday,
17th.
on Wednesday, 18th. I'm told that 17th, and I mean the Tuesdays and Thursdays are normally you have DB matters, isn't it? Tuesdays and Thursdays.
My lord, I am coming from other districts, so I want to have on 17th.
I understand.
If possible.
I understand, but you also have to understand that on 17th there will be a DB. So you have to wait for the DB to be over. By the time it gets over, it may be second half already. So whether it will be possible for you to take out the matter.
All right, my lord.
That's
18th,
why.
18th.
18th. All right. Give the date, okay? Yes. Any other mention?
May I, Your Lordship? Your Lordship, I beg to mention one unlisted matter to be listed tomorrow.
What is the urgency?
Your Lordship, there is an interim wherein the result of the written examination has been stayed.
has been stayed.
Yes, your lordship.
This is a pending matter.
Yes, your lordship. The matter was last listed on 2nd of March 2026, but due to paucity of time, the matter couldn't be taken up. Pleadings are completed, your lordship. The matter is to be listed for final disposal.
Final disposal. We have it on Monday or Wednesday, not tomorrow.
Okay, your lordship.
Have it on Wednesday. All right.
Okay,
Keep
your
the
lordship.
date. 18 March.
Much obliged, your lordship.
Next, please.
May it please your lordship, I like to mention item number 24 on behalf of the petitioner counsel, Mr. A. Bhattacharjee, for listing the matter of hearing after 2 weeks, and I have taken the consent and informed the other parties.
You want it after 2 weeks.
Yes, ma'am.
Why do you want adjournment?
There are some personal difficulties, my lord.
Okay, on a mention made on behalf of Mr. A. Bhattacharjee, learned counsel for the petitioner and not opposed to by the other side. Matter stands adjourned for 2 weeks. To be listed again on a date to be fixed by the registry.
Much obliged.
All right.
My lord, I'd like to mention item number 8.
Item number 8.
My lord, the matter may be listed after 2 weeks.
Why do you want adjournment?
But actually, this morning I've been informed that I've been informed by the other party. Other party's counsel's health is not well.
So you are mentioning for the other side.
I'm just
You are for the petitioner, but
yes, my lord.
and you're mentioning for the respondent. Somebody should mention for them.
Yes, but I've been requested, my lord.
Okay, on the mention made on behalf of the counsel for the respondents. What is your good name?
My lord, Difangu.
Sorry?
Difangu.
D. Pangu.
Yes, my lord.
Your name is not there. Item 8, isn't it?
Yes, my lord.
But this is listed by orders. I don't know. Somebody had mentioned it. Give me that file, please. Item 8. Let me see. If somebody has mentioned it for listing it today,
Yes.
then why do you adjourn it? What is the point of mentioning a matter and getting it adjourned again?
My lord.
Item number 8.
तुम किसका नहीं बोल रहा किसका
Item 8.
इतना तुम किसका on behalf में मुझे नहीं पता सर का oh my lord I'm so sorry I'm appearing on behalf of respondent my lord my lord the leading counsel K. Tama my lord it's not well so this matter may be listed after 3 weeks I've informed the petitioner my lord he's
Okay.
from the petitioner side.
Anybody has mentioned this matter to be listed
Yes
today?
my lord
Who had mentioned?
the petitioner my lord them
You had mentioned. Okay, who's not well?
K. Tama my lord he's the leading counsel here my lord.
For? He's for which respondent?
For private respondent my lord
Number?
for my lord.
So number. Mr. K. Tama, learned counsel for respondent number 4 is said to be in this post. So upon a mention made on his behalf and not opposed to by the other side, matter stands adjourned. To be listed again
After 2 weeks my
after
lord.
2 weeks. All right.
May I say, my lord?
Yes.
Well, I beg to mention item number 5, my lord.
5. Yes. What do you want?
With this, my lord, with consent of other side, my lord, I am praying for the listing of matter on 24 of this month, my lord.
Why?
This is being conducted by my lord, PD Nair, my lord. He's out station at Progan, my lord. With consent, my lord, he's praying for fixing the matter on 24.
24th. What is that date? Tuesday.
Yes.
Tuesday might have division bench. Take your chance.
Yeah.
Mr. L. Perme, learned counsel for the petitioner, submits that he is led by Mr. P. D. Nair, who is an outstation lawyer. And that as Mr. Nair has some personal difficulties to appear before the court today, he prays that the matter be posted on 24th of March 2026. So he submits that. He has taken the consent of the other side. Next para in view of above, list on 24th March.
My lord will kindly continue interim order.
Interim order passed earlier shall continue till the next date of listing.
Obvious.
Yes, Lordship. I beg to mention item number 20, Your Lordship.
28,
20, yes.
20.
Yes, Your Lordship.
You have
Service
to
upon
speak
response.
loud, okay? Yes, 20. What do you want?
Adjournment for today, Your Lordship. Services are still awaited, Your Lordship.
Let the matter be called 20.
Oh.
We'll see. All right. As and when the matter is called out, we'll pass necessary orders. Vanessa, you will call after the motion matters, you will call the orders first.
Sure.
Then thereafter, admission.
My lord, I wish to mention item number 10, 11, 12 for withdrawal.
10, 11, 12.
Yes, lordship.
Withdrawal. Why do you want to withdraw? You've got the relief.
No, lordship.
There has to be a reason.
Lordship,
Reason for filing, reason for withdrawal. What is the reason?
Lordship, senior was instruct me that three matters will be withdrawn today, and liberty may be given.
Who is your senior?
T. Tapak.
Tita Park.
Yes.
He didn't tell you why he wants to withdraw it. There has to be a reason, isn't it?
Yes, lordship.
What could be the reason?
Shouldn't-
This is non-payment of bill, Your Lordship.
Huh?
This matter is non-payment of bill, Your Lordship.
Non-payment of bill.
Yes, Your Lordship.
There is some clerical error in the writ petition or something like that that you want to withdraw it to file afresh. Something has to be there. Next time
Yes, lordship.
you get such instructions, you must know
Yes, lordship.
why you want to withdraw. Otherwise, liberty will not be granted by this court. There has to be a reason for that.
Yes, lordship.
Okay.
Yes, lordship.
On the prayer, your good name?
B. Sivo.
Mr. B. Sibo. Your name is also there. You don't know the subject. Mr. B. Sibo, learned counsel for the petitioner, submits that he has instructions to withdraw the writ petition. And he seeks liberty to file afresh as well. Considering the prayer, matter stands disposed of as withdrawn with liberty as prayed for. 10, 11, 12.
10, 11.
Keep that in mind next time.
Yes, lordship.
If you withdraw, you must assign a reason why.
Yes, lordship.
All right. Next.
Lordship.
Oh, Ms. P. Pangu, learned government advocate, appears for the state respondents. All right.
Adjourn करें.
Item number 1.
Yes.
May I please, my lord? My lord, this petition, my lord, the petitioner is challenging the, my lord, impugned transfer order dated 15/9/2025, my lord. The main grievance is, my lord, the petitioner has been subjected to, my lord, frequent transfer, my lord, basically for 4 times, my lord, within a year, my lord. And this last order, 15/9/2025, my lord, the impugned order, this was passed within a span of 3 months, my lord. Basically, my lord.
Where is it? Page number?
My lord, impugned order, my lord, will find at page number 19, my lord. Is an assistant engineer working in PWD. Page number 19, annexure 1, my lord.
This order is dated 9 September.
My lord.
You said 15/9.
My lord, sign, my lord, below, my lord, will find. It's below, my lord, after name, my lord, it is dated 15 September.
Okay, that's got 2 dates now.
My lord.
You are at serial number 3?
Serial number 3, my lord. Present posting place is Pipu subdivision, my lord.
From Pipu to you're going to
Pijirang subdivision.
Pijirang.
Yes, my lord.
This is a separate subdivision.
Subdivision.
How far is it?
My lord, it is of course within the Iskaming district, same district, but it is far. Most probably it will take 1 day journey, my lord.
Okay. And you have been posted in Pipu when?
My lord, my lord, will see my transfer. My lord, will find at page number 23, my lord. My lord. At the top, 17 May, it is retained. At the bottom, 26 May, my lord, 2025.
Ms. Pangu, Please explain why two dates are always given like that.
Here, Your Lordship, we have received the instruction, Your Lordship. Actually, in this.
No, answer the question. My question, specific question is that these orders, they are dated, a particular date is given.
Yes, sir.
And below, again, another date is given. Why is it like that? Any idea?
No, Your
No idea.
Lordship, no.
You should ask.
Yes, Your Lord.
This question has to be, will be asked to you again
Yes, Your Lordship.
next time.
Your Lordship, we have received one instruction, Your Lordship, from the department.
What is the instruction?
Approval, transfer approval, Your Lordship.
Transfer approval?
What happened, my lord? I filed one RTI, my lord, seeking the, my lord, the proposal,
Oh, proposal,
office
proposal,
noting,
Your Lord.
all those things, my lord. And answer given to my reply, my lord, my RTI reply is that there is no proposal, no reason, even no approval from the competent authority which I have annexed
Is
the
clear, Your Lord.
RTI reply, my lord.
For your transfer.
Yes, my lord.
Then today, what are you giving me this?
My lord, this matter can be, my lord, disposed, my lord.
No.
No, Your Lordship.
Let her submit. Why? What instructions you're giving? You're
This one-
simply passing a bunch of papers to me. At least explain. What is it?
Proposal for transfer and posting of assistant engineering, Your Lordship. Actually, Your Lordship, may I, Your Lordship, in this matter, AAGRS Navam is appearing, so he's not present
You
today.
say that from the beginning instead of, like
Yes, Your Lordship.
taking me here and there. You file your instruction.
Yes, Your Lordship.
What do you expect otherwise? That you will pass on one paper and court will read itself and pass an order by itself? Like that?
No, Your Lordship.
And we don't require any counsel to appear before the court at all. We'll quote papers directly from the department. You're here to assist the court.
Yes.
At least tell us what is what.
We need some more time, Your
Ms.
Lordship.
P. Pangu, learned government advocate, submits that she has received the instructions and prays for a week's time to file the same by way of an affidavit. Praise the Lord.
My lord, interim prayer, my lord. This interim what
Interim-
What interim order?
my lord, this
There was no interim order the first date. The
Yes,
first
sir.
date
Well,
was today.
today, my lord, it's for records, my lord.
No.
The matter has been called, my lord.
The affidavit should be filed within a week so that matter can be disposed of at the next stage, at the next, on the next date of listing. List on 17th, list on 18th of March. You file.
Okay, Your Lordship. Otherwise, Your Lordship.
You take back your instructions.
Item number 2.
May I plead your lordship?
Yes.
My lord, the petitioners two in numbers, my lord, they are aggrieved with an order, my lord, whereby both of them has been directed to vacate their quarter, my lord, wherein they are staying since their appointment in the service.
Where is the order? Page
Order is a page 36, my lord.
36.
Yes. This is the second one, my lord. First order is at page 31, my lord.
31.
Yes. May I read, my lord?
Just a minute.
Oh.
Page 31. This
Yes.
is Annexure 3, is it?
Yes, ma'am.
You are at serial number?
I'm at serial number 1 and 6, my lord.
1 is petition number 1.
No, 6 is petition number 1.
6 is petition number 1.
Yes, ma'am.
And serial number 1 is petition number 2.
Yes, ma'am.
And where is this quarter?
This quarter is at D sector here itself, my lord.
D sector.
Naharlagan, ma'am. D sector, Naharlagan.
And both of you are working as UDC.
Yes, ma'am.
Then page number 36 is the second letter.
Yes, my lord. And
This
by this letter, my lord.
Just a minute.
Yeah.
Page number 36.
Yes.
Meril Megu. This is petition number 1.
Yes, ma'am.
Then the other one is Omi Taga.
Yes.
This is serial number 1.
Yes, ma'am.
Petition number 2.
Yeah.
Just a minute. Of January, then the 2nd February. Where are you now, today?
In the quarter itself.
You are still in the quarter.
Yes, ma'am.
Date has been given to you 15 February to vacate.
Yes, ma'am.
How you are staying there till now?
Because
What about the others? All of you are staying.
others, ma'am, although affected employees are 8 in numbers, my lord. This serial number 3 and 6, my lord, they even approached the honorable court, my lord.
Then
And they have a very limited prayer. Although we are affected by the same order, my lord, our pleading and
what
prayer
happened in that case? 3 and 6 when
they
they
saw-
filed.
they sought for, my lord, a vacation of the quarter by March, and one of them till a short time till April, my lord.
Okay. So what was the order passed by this court?
Lordship, I have the order here.
What is it?
Lordship, in other the court,
Was it allowed?
no, Lordship.
They wanted some.
Partially, Lordship, because
What do you mean by partially?
other one till 16th March, she has been allowed. And in the other petition, she has been allowed till
Till
6th of March only.
6th of March.
Yes.
Okay, they wanted to stay a bit longer. Court has allowed it.
Till March only.
Till-
Because I was asked to
No,
bring
date is
instruction.
irrelevant. Date is irrelevant. I'm asking you, these are the two people that come before this court and court has allowed them to stay up to a limited period of time.
Yes.
That's all, isn't it?
Yes, yes. That's why I'm saying Lordship.
So that matter, those matters are disposed of.
Disposed of
Disposed of.
with this direction.
Okay.
And then
And what is the latest? 6th March.
latest is 6th
I mean,
March and the longest one is
The longest one is 16th
16th March.
16 March.
Yes, Lordship.
What is the reasoning given?
Lordship,
Why difference of that 6th and 16th?
the 16 March one, she had a children studying, writing his
Exams.
exams. 15th March.
Till 15 March. So till 16 March time was extended.
Yes, Lordship.
But she prayed for how long?
She prayed for
Till
Lordship,
April.
Till April.
Till April. Okay. Now in your present case, what are you praying?
My lord, our prayer is to allow us to stay in the quarter till our retirement from service, my lord.
Okay. When are you retiring? When are you retiring?
Petitioner number, my lord, 1 on 2031, my lord.
31.
Yes.
So another how many years? 5 years.
Nearly 5 years, my lord.
Okay. Why you like the place so much? You don't want to leave.
No, my lord,
You don't have any other means to go anywhere else.
no,
See,
my
the
lord.
reason why they want you to vacate is that the building is dilapidated. There's a risk for your life also.
Yeah. No, that is
Some
what,
chunks will fall from the ceiling, then what will happen? The
Look,
building will crumble, then what will happen?
Lord, our plea is that this notification itself is an IWAS, my lord. No multi-story building will come up, my lord. The same place has already been allotted to private individuals, my lord.
No,
And
Lordship.
concrete structures have also come up, my lord.
No. If that is the case, we'll ask her to obtain instructions.
No,
If-
Lordship, in Itanagar, it has already been built. The second scheme, they have chosen this sector, Lordship.
Miss Atte, you tell me, why do you want to vacate this quarters?
Lordship, may kindly see the 31, page 31.
No, you tell me, you have read it already, page 31. You've read.
They are going to build a big building, lots of construction, where there will be multi-place will be built, place, Lordship. And they will be given, first priority will be given to this quarter holders, Lordship. Lordship, we'll see here, Lordship, in the order itself is there, Lordship. And
No, the order it is there, but the petitioner is not believing. He says that no, this is an eyewash.
I was asked to take instruction also.
So take instruction in this also.
No, Lordship, the instruction I have got already in that earlier case. It
So
was last
that
week
will
only.
cover this case also.
Yes,
Your instructions in the other case will cover this case also.
yes, Lordship. Of course.
Show us what instruction is that.
Yes, Lordship. This instruction I got. Lordship, they are giving them alternate this one
Where?
resident.
Where?
Here is the Lordship.
No, here
Rent
itself.
process, rent
Where?
process they are providing, Lordship.
Where?
In Nahalagan itself, Lordship. If they don't choose the rent house, then they are being given HRA, Lordship.
What is the name of the quarters this is a one unit quarter or different quarters?
Different quarters, Lordship. That
Okay.
whole place will be taken and a big building will be built, Lordship. Construction will.
Government residential quarters at D sector.
Yes.
What is that place called? Government quarters only.
Government quarters only. Of course.
Does it have any particular name for that area?
Government quarter under general pool, it is.
Yes.
Government quarters general pool in D sector.
Yes.
This sector.
For redevelopment purposes for construction of multi-story flats as per government notification dated so and so. Urban Affairs.
And this. Lordship, may see this earlier order, Lordship. It passed in WPC, other two WPCs, Lordship.
My lord, this serial number 5, my lord.
No.
Yes.
She equally should have been affected by this order, but she is not agree because her husband, who is an engineer in the department itself, my lord, they have already got allotment. So we have filed RTA application for that also.
Allotment where?
Lordship.
In the same, in the adjacent of the quarter, my lord. Some portion of the quarter also is there, my lord.
Which is not going to be dismantled.
That will be dismantled, but not by the government. It will be allotted to private individuals. As soon as we move out, my lord, this structure will be erected, my lord, by private individuals only, LOT. And what about, my lord, the foundation structure has already come up, my lord, and no notice has been issued to them. The husband of this serial number 5, my lord. Concrete structure has already come up, my lord, although on foundation stage, my lord.
Lordship, in the earlier WPC, Lordship, item number 8 and 3 were here.
That is the trend going on in the, my lord, Itanagar capital region, my lord.
Lordship, this is
Quarters are dismantled that way, my lord.
for the betterment of the welfare of the state only, for the employees only, Lordship. Here, they have said also, Lordship, that they will be given the allotment first in the new building, Lordship, in the new place.
So the old building will be demolished
Demolished, Lordship.
and new building will be
Structure
constructed.
will come
And,
up, Lordship.
and that new building, they'll be given allotment. Okay.
8 priority, Lordship. And in
And-
between also they are given rent houses, Lordship. They are being
And-
accommodation is given, Lordship.
How long is the construction going to take place?
Lordship, in Itanagar, it took around 2 years only.
2 years. So.
Yes.
So what are you saying? What is he saying about that private allotment and all that?
Lordship,
ma'am.
this never came up earlier in the earlier, this one also.
What do you mean
petition
private
also.
person will construct and all that?
My lord,
Lordship, this
erection has
can
already
be-
Direction by
been
who?
done, my lord. This husband of this serial number 5, my lord.
No, it is a government quarter, isn't it?
Yes,
It's a government land.
yes.
How a private party can erect a building?
That is why, my lord, I
Where
have
is your
submit-
statement?
Yeah.
Take me to your writ petition and your statement,
my lord,
where you say that private person has erected a pillar.
yes.
Where is that?
Mhm. My lord, in our representation, my lord,
Not your representation. There has to be a specific allegation. Don't make submissions like that without
Yeah.
there being any pleadings.
yes.
And Lordship, the petitioner's prayer to allow them till retirement is, Lordship, this cannot be.
Why not after retirement also?
Lordship, then someone will come and they will say the same thing,
He
Lordship.
wants only till retirement. You
No,
give them till after
someone-
retirement also.
so till 31, someone till 36, then others who are there would be, Lordship, 40, and then it will never be built, Lordship. And then because quarters are, they are staying in quarters, backside of the quarters, all are, Lordship, encroached, Lordship. That's the reason they don't want to give away, Lordship.
So what he means to say is that there's some encroachment. So people, private parties are also building.
No, what
So-
Lordship, the government is taking all the place, is big structure is coming up because in the small place, big structure that cannot be, is Lordship, even in Itanagar, more than 70, 80 plus has been built, Lordship. That way more employees can be accommodated. So in the quarter, only 8.
My lord,
Yeah,
at
Lord,
page
sorry,
11 of my petition, I have mentioned, my lord. that it is for this honorable court to see to it that the petitioner has been
Which
actually
paragraph?
paragraph 11, page 12, my lord.
Hmm.
That it is
You
for
said
this
page
honorable
11.
court to see
Now you said page 12.
12, my lord. See to it that the petitioner has been actually made a sub-target by the respondent authorities in as much as the adjacent quarters has already been allotted to private individuals, and as such the notice dated 12 January 2026 issued by the commissioner Urban Affairs and subsequent letter dated 2nd February 2026 issued by the executive engineer Itanagar division Itanagar are nothing but an was to indirectly vacate the petitioners from their quarters. The respondent authorities are adopting pick and choose policy in granting land allotment to some occupants, while the petitioners are being targeted only to create avenue for affording land allotment to some vested interest.
These are two different subjects. Just because somebody has been allotted government land somewhere nearby, can you say that I am staying here in a quarter, I will not move from here?
No, my lord, the quarter.
Or unless you give me also one more allotment like them, I will not move from here. Can you say that?
No.
That's a different entirely thing. See, let us not be distracted by allotment illegally given maybe to somebody.
Yes.
You are there in a quarter.
Yes. Ma'am.
This is not your own private property. It's a quarter.
Yes. Ma'am.
And the government has made a plan that they will construct a high-rise building. Multi-story building will be there. Quarters will be there. In the meantime, for you to shift out, they are also saying that you'll be given suitable accommodation elsewhere.
Yes.
You'll be allowed HRA and all that. So please vacate. And once the quarter is ready, the new building is ready, we'll give the preference to you. This much they're saying. Why are you saying that I will not move? I will stay here till I retire. You cannot say that. What right do you have to stay there?
My lord, because we know that this government building will not come up, but private.
Your knowing that building will not come cannot be the reason for you not shifting out from there. For any XYZ reason, they can shift you out from there.
But my lord, the portion of the
but it has to be in a manner in which you are given some alternative. You have been given some alternative.
But we have
so you don't have an indefeasible right to stay put there. And like I said, since the building seems to be an old building, there's risk also for you.
No, we have renovated it nicely, my lord. We have no problem because we have all on all resources.
I'm sorry, I can't allow that. See, there's already an order passed by this court.
Yes, sir. My lord,
we go by that only. See.
My lord, then in that case, my lord, this our press representation that may be allowed to be considered and disposed of. The department has to answer, my lord. Allegation leveled by us, my lord.
Which allegation? Where is the representation?
Representation, my lord.
And what allegation have you made? Page?
37 to
37.
37, my lord. On 37 onwards.
See, again, you are talking about encroachment. So these private other parties have been given, they have encroached the government land.
Yes, the encroached portion of
encroach means this is not, if you say encroach, it is not as per law, isn't it?
Yes, ma'am.
It's unlawful to encroach. Correct?
And encroach.
Now, what you are saying that you also want to encroach?
No, my lord.
You want to stay in the quarter?
Yeah.
You're saying that others have encroached, I also will not move from here.
No,
you give me this quarter also. That's what you're saying, basically.
No, my lord, allotted area.
That cannot happen, Mr. Counsel. It's wishful thinking.
Allotted area covers our quarter also, my lord. Our quarter will be.
So it is for the government to take a decision to evict those who have illegally encroached. Who are you? Supposing it's in case of appointment. Mr. XYZ people have been given backdoor appointment. You are saying that I also am eligible to get backdoor employment.
But
why don't you give me backdoor employment too? Can you do that?
My lord, but at least we have a right to be heard, my lord. So our representation may be kindly disposed of, my lord. Till such disposal, my lord.
Okay, dispose the representation within a week.
Within a week.
Until then, don't insist them to go out.
Yes.
And the whatever decision is taken, you have to abide by that. All right, Mr.
And Padama.
N. Pada, learned counsel for the petitioners, and Ms. G. Ete, learned additional senior government advocate, appearing for the state respondents. Stop having regard to the nature of grievance projected by the petitioners. The writ petition is taken up for disposal at the motion stage. Next para, the petitioners are aggrieved with the notification dated 12/1/2026, bracket annexure Roman 3, and the communication dated 2/2/2026, bracket annexure Roman 5,
Yeah.
by which they have been asked to vacate the government residential quarters which they are occupying on the ground that the government is going to develop the quarters by constructing a new building.
New multi-story building, Lordship.
New multi-stored building.
Yes, Lordship.
The learned counsel for the petitioner submits that, in fact, some private parties have encroached the government quarters and land, and while the government is not taking any action against them, they have asked the petitioners to vacate their respective quarters within a time frame. He submits that the petitioners also have not been heard before they have been asked to vacate the building. Stop the representation submitted by the petitioners on
9/2/2026, man.
where is that page?
Page 37, man.
On 9/2/2026. Before the which
All the
respondent?
respondents, man.
Huh? How many respondents are there?
3 respondents.
Before the respondents
Yeah.
have also not been considered and disposed of till date. Stop the learned counsel therefore submits that the impugn notification and the communication as stated herein above should be set aside. Next para, Ms. G. Ete, learned additional government advocate, senior government advocate, on the other hand submits that the petitioners have been asked to vacate the government quarter by notification dated 12/1/2026 on the ground that the government has taken a decision to construct a new multi-storied building.
Lordship, dismantling the old residential quarters for construction yes, Lordship.
By dismantling the old crumbling structures in the government quarters. Stop. She submits that the government has also decided to provide alternative temporary accommodation or avail house rent allowance till the new multi-stored building is constructed. So the government has also taken a decision to reaccommodate the government employees who have vacated their respective quarters in the first lot on completion of the construction of the flats. So despite the same, since the quarters have not been vacated, another communication was made to the employees concerned, including the instant petitioners on 2/2/2026, requesting them to vacate the quarters by 15 February 2026. So, however, the petitioners have refused to vacate the quarters. Stop. She submits that similarly situated persons who were also aggrieved by the impugned notification and the communication had approached this court. And one such case being WPC number 59 of 2026, bracket Srimati Tongam Basar versus State of Arunachal Pradesh and 3 others, close bracket, comma, this court, upon considering the grievance projected by the petitioner and the instructions received by the Government Council, disposed of the writ petition by allowing the petitioner therein to stay till the completion of the examination of one of the children. That is 16 March 2026. Stop. In the meantime, the petitioner has been asked to decide whether she would avail the alternative temporary accommodation or avail for house rent allowance. For stop, this court had also made it clear that the petitioner should vacate the quarter or not before 23/2026. Stop. Ms. G. Etel on State Council therefore submits that even in the instant case, the grievance is against the impugned notification as well as the communication of 2/2/2026. And the prayer of the petitioners that they should retain the quarter till they attain the age of superannuation cannot be allowed by any means. Full stop. She therefore submits that a similar order may be passed in the instant case as well. Next, para, having regard to the above projection by the petitioner and the instruction received by the learned State Council, including the earlier direction passed by this court in a similar case, this court is of the considered view that the petitioners cannot be said to have the right to remain in the quarters. In view of the decision taken by the state government for construction of new multi-story building to accommodate its employees, including the writ petitioners. It is also seen that despite the last date for vacation being given as 15/2/2026, the petitioners appear to be still residing in the state quarter. And further, the projection made by them is that their representation filed on 9/2/2026 is not yet considered and disposed of till date. To stop, in that view of the matter, the respondents are directed to consider the representation submitted by the petitioners on 9/2/2026 within a period of 1 week from today by passing appropriate and reasoned order. It is provided here in that till the representation is considered and disposed of as directed herein above, the petitioner shall not be forced to leave the quarters. However, depending upon the decision taken by the respondent authorities concerned, it would be incumbent upon the respondents, upon the petitioners to comply with the order to be passed as directed herein above.
My lord, that may not be because, my lord, there should be avenue for further appeal also, my lord. Because
No. What do you mean appeal?
Lordship, they are all ready to start the construction, demolish and start the construction, I have been told, and because of their non-vacation, Lordship, of the quarters, they are tied down, Lordship. The construction group is.
I said 1 week. Today is 11th, isn't it? By 18th, you have to pass the order. So you will not continue in that place beyond 20th of March.
Yes, Lordship, that maybe, Lordship. Made clear, Lordship, because the other one is only up to 16, 20, other one also in the repetition, earlier repetition.
The petitioners at any rate shall have to vacate the quarter by 20th of March, 2026. The petitioners shall also decide as to whether they would like to avail the alternative quarters to be provided by the agency in terms of the notification dated 12/1/2026 or avail for house rent allowance. All right.
Much obliged.
Item number 3.
Yes.
If it may please, Your Lordship. My lord, the petitioner's hearing is aggrieved by the action of the respondent authorities in not paying him the subsistence allowance, Your Lordship.
Subsistence allowance.
Yes, Your Lordship.
When were you suspended?
On 4/1/2023.
Where's the order?
It is in Annexure 7, Your Lordship, page number 57.
57. Your 57 page is not legible.
At 58 is the type copy, Your Lordship.
You want to spoil my eyes further, huh?
No, Your Lordship.
Okay, 58 is the type copy.
Yes, Your Lordship.
Deemed to have been suspended from detention since 2023.
Yes, Your Lordship.
And the detention suspension is from 22.
Yes.
Why have you come now?
My lord, the petitioner has also written a representation to the respondent authorities, Your Lordship, and he was expecting that the subsistence allowance would be paid in the meantime, but
When did you submit your representation?
in the year 2023 itself, Your Lordship.
23.
Yes, Your Lordship.
Today's 26. 2 years you were not doing anything. I don't think you require subsistence allowance.
I do, Your Lordship.
Yes. Anything?
I have to seek instruction on that as to why.
Definitely. It's the entitlement of the petitioner.
Yes.
Suspension, then subsistence allowance, and there has to be a review of the suspension also. There's a settled law. He may not require it, but he has to be given.
No, I do require it, Your Lordship.
You're coming after 2 years, so that's why I'm thinking that you may not require it.
No, Your Lordship. It is in fact the respondent authorities have been making the petitioner run from pillar to post, Your Lordship. That is why the petitioner could not be here
Okay.
sooner.
I heard Miss
D. Tamuk.
D. Tamuk, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner is seeking a direction to the respondent authorities to pay him the subsistence allowance on being suspended by order dated 4th January 2023, with effect from the date of his detention, that is 30/12/2022.
Lordship, after that he was terminated. And then he has approached before this honorable court.
And then it was stayed, Your Lordship.
The termination was stayed.
Termination was stayed.
Yes, Your Lordship.
By this honorable court.
Which order?
By
By which order?
6/4/2023, the order was stayed.
Page,
It is at
page?
Annexure 9, Your Lordship.
Page?
Annexure 9, page number 66. This is the order of after the petitioner was terminated, he challenged it before the Honorable Court, Your Lordship. And this Honorable Court, by this order, 6/4/2023, was pleased to stay the order on the ground that the said order was stagmatic in nature, Your Lordship. And since this order is stayed, Your Lordship,
Any appeal?
no, Your Lordship, no appeal against this order. Still pending.
What did they say last? Please read. Stop. The learned counsel for the petitioner submits that apart from non-payment of subsistence allowance, the order of suspension has not been reviewed by the authority concerned. Full stop. She, however, submits that the petitioner was terminated by order dated 2/3/2023, which was signed on 7/3/2023, and against which he filed WPC number 182 of 2023 before this court. Stop. This court, white order dated 6/4/2023, passed an interim order staying the order of termination upon finding the same to be stigmatic. Next para, in view of above. Short date. Issue notice returnable by.
That would be in this coming week, Your Lordship,
This coming week means
starting from 16th, Your Lordship.
returnable by 18th.
Yes, Your Lordship.
19, Lordship, kindly. 59.
Returnable by 19th of March 2026. Mr.
Gyatso.
T.
Gyatso.
T. Gyatso, Learned
Department.
Standing Counsel for
Horticulture Department.
Horticulture Department accepts notice on behalf of respondent numbers 3 and 4. While Ms. P. Pangu, Learned Government Advocate, accepts notice on behalf of respondents numbers 1 and 2. Stop notice is therefore complete. Extra copies of the writ petition be furnished to the Learned Counsels appearing for the respondents today within 2 days. The Learned Standing Counsel. Mr. T. Gyatso shall obtain instructions as regards non-payment of subsistence allowance to the petitioner, and also as to whether the suspension had been reviewed by the authority concerned by the next date. List accordingly.
Much obliged, Your Lordship.
My lord, I'm sorry, my lord. I'm praying for accommodation in item number 6, my lord. I'm sorry, my lord. My name is also not shown. Had it with my lord, my name is shown in the, I could have mentioned earlier, my
You
lord.
have come just now.
My lord, I have not seen, my lord.
You have
Now,
come-
just
you-
go.
You have come just now.
No, my lord. This morning I came, my lord. Even
You
in,
know.
no, my lord, in this case, what happened? We have already sent the, my lord, our affidavit to be vetted by the DGBR, my lord. Now matter is pending there, my lord. We'll file a short affidavit.
Mr. Saikia, you are for the petitioner. State.
Yes, ma'am.
When will you file the affidavit?
Within 3 weeks, we'll file, my lord.
My lord,
That is,
let them take, my lord, 10 days time, my lord, because my lord, they have taken sufficient time, my lord. Otherwise, the matter is, my lord, already settled by the Supreme Court, my lord, in Mihin Lalin case, my lord. My lord, the case is, my lord, My lord, the award was passed under the Jumland, my lord, and we have protested, my lord. The award should be passed on, my lord, in terms of the new act, my lord. Now, my lord, Supreme Court has settled that, my lord. Even the acquisition took place under the Jumland regulation, my lord. The award has to be assessed in terms of the, my lord, new act, my lord. That is the only, my lord. So, my
Now,
lord,
what is the process? That affidavit you are saying?
My lord, affidavit, my lord, everything has been said only for betting,
On what basis are you saying you want 3 weeks?
just for the betting, my lord.
Waiting.
Yes.
Where is the affidavit now?
It is in DGBR, my lord.
DGBR.
Director General Border.
When did you send it?
My lord, I'm sorry, my lord, I am not
Exactly.
my lord, having the copy, my lord, my file. So therefore, my lord,
Yet you want adjournment. Mr. M. Katolan at DSGI submits that the counter affidavit of the respondent Union of India has been sent for vetting, and the same is lying with the DGBR. Stop. He submits that he may be granted 3 weeks' time to file the counter affidavit. So stop. Mr. R. Saikia, learned counsel for the petitioners, on the other hand, submits that sufficient time has been granted to the respondents for filing counter affidavit, and that the issue involved has already been settled by the apex court, and therefore the matter should be taken up for consideration at an early date. Considering the above submission, release the matter again on, give a date. We'll give a date. Today is what? 11. I'll give you 10 days time.
then, my lord.
Release the matter again on 25th of March.
Hello.
my lord, just a small correction, my lord. My name may be also shown in the cause list.
Okay. Name of Mr. M. Kato, DSGI, be reflected in the cost list hereafter.
Much obliged.
Item number 20.
No, you call from item 16.
Okay, you took
Orders. We will finish the orders, all the orders first, then go for admission.
item number 16.
My lord,
Yes.
my lord, we were directed to issue notice to respondent number 3, and accordingly we have taken steps. And AD has been also received and placed on record.
You were directed to take steps, not to issue notice. Court will issue the notice.
Yes, we were
Not-
directed to take steps.
Have you taken the steps?
Yes, Your Honor. Yes, my lord.
To which respondent?
Respondent number 3.
3. AD card has come back?
Yes, my lord.
Okay. Who's respondent number 3?
Respondent number
Techi Totu Tara, executive engineer.
executive engineer.
Okay. AD card. Now, have you checked the AD card?
No, my lord.
You should check. Somebody has signed. I don't know what is this. Necha Kara Techi. What about 1 and 2?
We were not directed to
Notice has gone only to 3.
only 3.
I see. Okay. Now, thing is that name of the respondent number 3 is something else, and the signatory of the AD card is somebody else.
Okay.
So can we accept this as that notice is delivered? Hmm?
Maybe someone has accepted on his behalf from his office.
That's why. And he might not have given him also that copy. We don't know. There's no seal, nothing like that. Supposing somebody from the office has accepted it, so they should give a signature with seal and all that, so that we know that somebody has received. But there's nobody. Can you serve by way of Dusty?
By way of dust is very difficult for us because it's in Sagali and
Sagali. Okay. Office note dated 10/3/2026 indicates that AD card has returned back from the respondent number 3. Stop. Be it stated herein that this court, by order dated 17/9/2025, had only issued to respondent number 3. Stop. The AD card. No. Stop. On perusal of the AD card, it appears that the signatory is not the person. The signatory is not the respondent number 3, but somebody else. Stop. Under the circumstance, the petitioner may be required to take fresh steps on respondent number 3. Now, however, before making such a direction, we may await appearance of respondent number 3 in view of the AD card, which has returned back. List the matter again after a week. Stop. If nobody appears for respondent number 3 on the next court date, the petitioner may be required to take fresh steps. Let us see. Somebody may appear. If they appear, not required. If they don't appear, you have to take fresh steps, because the signatory is somebody else. We don't know. He may come later on and say that I'm not me. I have not received it.
yes, sir.
This is not my signature. All that thing will come.
Item number 17.
No.
Respondent.
Okay, this is for referral. Yes, we can continue with this. You can continue all this till here. Then we have one part matter. We'll go to that. Item 4. Yes. Yes. After 23. Yes.
Your Honor, I'm for respondent number 1, Your Honor.
Respondent number 1. Yes. What about the other respondents?
Is here.
The respondent is IOC. I'm appearing.
And petitioner is absent in last occasion also, Your Honor.
You're for the IOC.
Yes, yes.
I'm informed that
Both of you are the respondents.
Yes, Your Honor.
Okay.
Yeah.
Who's for the petitioner?
petitioners.
Last occasion also he was absent, Your Honor. So in that case, this matter may be
I'm
dismissed.
informed that he has died. That Mr. I. Ahmed.
Oh,
Who?
Petitioner.
oh,
Advocate.
counsel for the petitioner.
Counsel has died.
Oh. When did he expire?
A few months ago.
In fact, there's no merit in case, Your Honor.
What is the case about?
The petitioner want to continue with this deed of agreement, Your Honor. This deed of agreement was expired on 2024, Your Honor. So even after they want to continue with this.
Please write none appears for the petitioner when the matter is called. It is submitted at the bar that the counsel for the petitioner, Mr. I. Ahmed, is no more. Mr. T. Tapak, learned counsel, appears for respondent number 2.
Two, yes, 2.
And your good name?
Mudang Opo here.
Sorry?
Mudang Opo.
Mr. M. Opung,
Yes, M Opo. For
learned counsel, appears for respondent number 1.
Yes.
Next para, in view of above, registry shall issue notice to the petitioner by speed post, informing about dependency of this case and for making alternative arrangement. Let the matter be listed again on April 1, 2026. Respondents to file their counter affidavit in the meantime.
Knowledge.
If there is no case, you say that in the affidavit, okay?
Yes, sir.
Since somebody has no more, so at least some notice should go. Yes.
Item number 18.
Yes.
My lord, I'm sorry to say, my lord. The item number 18, my lord, we require to file the affidavit, my lord. 1 week's time may be granted, my lord.
Respondent number 4 and 5.
4 and 5.
Otherwise, 2 and 3 already filed. I have received it.
Respondent numbers 2 and 3 have filed their counter affidavit, but respondent numbers
4 and 5.
4 and 5
Education department, my lord.
have not filed. And they are represented by Mr. D.
T. Tagum.
T. Tagum.
Standing Council of Education.
Standing Council Education Department. The learned Standing Council prays for how much time?
1 week, my lord.
A week's time to file the counter affidavit. Praise the Lord.
My lord,
List
let's
again
list
after
after week, my lord.
List again after a week.
My lord, may I direct registry to reflect my name, my lord. It's not in the code list. My name is not there.
Or
Yes,
name
sir.
of Standing Council
Education
Department be reflected in the cost list hereafter.
Deeply applied.
All right.
Item number 19.
Malad, we have filed our affidavit, Malad. One and two.
My lord, here, the petitioner is questioning the appointment as well as the continuation of Rathore 4 as Chairman, Regulatory Commission. Now, in view of Article 319D of the Constitution,
affidavit not filed.
Now, affidavit has been filed.
When?
By respondent 1, 2, and 3.
Your Lordship,
3 they have filed it today.
Today I am filing,
Today?
my lord.
And I have
Today you filed.
I have filed, my lord. Might have not reached your Lordship's desk, my lord.
When did you file?
This morning, my lord.
This morning, of course. How will it reach if it's this morning?
1 and 2 we have filed.
No. Respondent 4 has appeared.
My lord, I am for the private respondent number 4 and I am filing today, my lord.
So my prayer is that let the matter come upon 6th and effort we may be made to dispose of the petition on that day.
6th of.
In the meanwhile, respondent 4 will file and it will complete.
Mr. Jamo is for respond number?
3, my lord.
Mr. What Jamo?
T. Jamo, my lord.
T.
T. Jamo, my lord.
Mr. T. Jamo, Learned Standing Council.
For the Arunachal Pradesh Private Education. There is a
Give me your name.
regulatory.
Oh, you write Learned Council appearing for respondent number?
3, my lord.
3 submits that he has filed counter affidavit this morning. Stop. It is, however, seen that the same is not yet connected to the record. Stop. Mr.
R. Riba, my lord.
R.
R. Riba.
Riba.
Yes,
Mr. R. Riba, Learned Council appearing for respondent number 4. Submits that he will be filing the counter affidavit of respondent number 4 today.
Yes, ma'am.
During the course of the day. Stop. Anybody else is required to file?
No.
That is complete.
One and two we have already filed.
Okay.
Your Lordship, may kindly make one observation, my lord. Our name is not reflected here, my lord. Another lawyer's name is reflected, my lord.
Mr. N. Ratan, learned additional AG, appearing for the state. Bracket respondent numbers.
If 1 and 2.
1 and 2 submits that counter affidavit has already been filed by the state respondents. Next para, considering the above, let the matter be listed on
6th
of April,
my lord.
as agreed to by the parties.
But
The respondents are at liberty to exchange their pleadings in the meantime.
we may be allowed to file a register if necessary.
That's what I'm saying. Are at liberty to exchange the pleadings in the meantime. The registry shall verify and connect the affidavit in opposition filed by respondent number 3 to the record. Name of who has to be reflected?
My name, my lord, here.
T. Tagum.
T. Tagum has been reflected, my lord. T. Jamo should be there, my lord.
Okay. Name of Mr. T. Jamo be reflected in the cost list instead of Mr. T. Tagum. All right.
I'm assisted by
Verma.
J. Ahmed in this case, Mala. For the petitioner.
Okay. Your good name, Mr.
DK Das, I am here.
DK.
DK, D for Delhi. DK Das.
Mr. DK Das, learned senior counsel.
Assisted
Yes,
by Abhay Verma.
Huh?
Abhay Verma, sir.
Appears for the petitioner and is assisted by
Abhay
Mr.
Verma.
Abhay Verma.
Abhay Verma.
A. Verma.
Yes.
Okay.
6th of April.
6th of April, yes.
But in case the matter is about that is continuance of which we say that constitutionally it is not permissible. So effort may be made on 6th to dispose of the petition, if it's possible.
Well, I said, as agreed to by the parties, what did I say? List on 6th of. And I add one more line, on which date an attempt shall be made to dispose of the case finally.
Observe.
All right.
Hello.
Item number 20.
Yes, somebody mentioned this in the morning. You had mentioned.
Yes, your lordship.
Who had mentioned? You had mentioned.
Yes, your lordship.
Why did you mention?
Just for adjournment, your lordship, as the service is not completed yet.
The AD card has come back. Have you checked the file? You should check the file.
I have not checked the records actually.
You should check the file.
And also there has been a delay in giving extra copies to the state council. So
I have not received extra copies yet, Your Lordship.
That is another thing. But regarding the service, you should check the file. Office note whether service is complete or not. So that you inform the court. And the court will, instead of looking at the thing itself, immediately can pass the order to save time. Please write down office note dated 10/3/2026 indicates that AD card has come back from respondent numbers 4, 6, 7, and 8. But not from respondent numbers 5 and 9. So as such, notice is accepted to be complete on respondent numbers 4, 6, 7, and 8. 4, 6, 7, 8, 9, 4, 6, 7, 8, and 10. Stop await service report from respondent numbers 5 and 9. Await service report, cancel that. Instead, you write, registry shall track the postal consignment of the notice sent to respondent numbers 5 and 9 and put up a report by the next date. Learned counsel for the petitioner shall furnish extra copies to Ms. R. Basak, Learned State Counsel, within
2 days.
2 days. List again after 2 weeks.
3 weeks, Your Lordship.
3 weeks.
Okay.
Item number 21.
We'll complete till 23, then we go to the part hard matter. This is for referral for mediation.
Mediation. Lordship, I'm on a behalf of HK Pupon Insurance for the insurance company. Lordship, company is not agree for the mediation settlement.
Company is not agreeing.
Yes.
Why?
Because
Nobody is forcing you. Mediation means you try to attempt.
but
If it can be settled well and good, If it cannot be settled, then he'll come back and court will decide. Why don't you want to make an attempt?
No, Your Honor. Already, I have directed for that.
What is your good name?
Dilong.
D?
Dilong. My name is not reflected because my name is not reflected.
You're appearing for whom then?
I'm on a behalf of this HP Pukon.
What do you say, Mr. Counsel?
Lordship, the matter is very old. It was already referred to the mediation on earlier occasion.
Okay.
And it came back to the again in this regular court now.
Okay.
And the matter was already, the award was made in 2023.
Mm.
And claimant here is already dead. There were two claimants. One of them that died due to the old age. And then another is already in the verge of her old age. She's suffering from so many all these problems. Now the matter has to be, Lordship, it has to be fixed and disposed as early as possible, Lordship.
So that submission is made for the first time?
Lordship.
If it's that there's urgency in the matter, person is old, are you mentioning that for the first time?
Lordship, I have already earlier, I have also mentioned this matter also.
No, it has
and
been
we have
listed.
withdrawn they have deposited the half of the amount, 50% amount that we have availed.
Maybe, but you're saying that there's urgency in the matter and should be listed on priority basis. Nobody has mentioned that earlier. 1825, it had nobody informed.
1825.
None appeared for the appellant. Then you are Mr. Tatak?
Yes, Lordship.
You were present that day.
1825. It was listed for mediation.
You should have informed the court that time only that we.
Yes, they didn't turn up, Your Lordship.
Where? When was it referred for mediation?
8/1/18/2025.
No, it was not referred at all. It was listed only for referral to mediation.
Lordship.
It was not referred. So, question of mediation having failed doesn't arise. Are you agreeable for mediation?
Lordship, if they doesn't agree, then now I'm not the appellant. They are the appellant, Your Lordship. In this court.
Lordship, we will be settling the matter in regular court.
What is the why have you filed this appeal? On what ground? You don't know.
No, actually, I've not instructed that.
What is the matter, Mr. Counsel?
Lordship, the direction was made to make a payment of for the claimant. My son, he was victimized and died in an accident in the year 2017. And thereafter, we have claimed the MSCT board in Alo, Sessions Court Alo, MSCT. And therein they have awarded us. The award was given on 31/5/2020.
Award was made on fault basis or no fault basis?
It was
under what?
No fault basis.
Your claim was on which basis? 163A?
Yes, Lordship. That due to the accident.
No.
No fault liabilities have already been paid.
Your claim was made on fault basis or not? No fault
liability.
No fault basis. And how much was awarded to you?
Total amount, it Lordship.
15 lakhs. How much? 15 lakhs, 15,203. No, this is 50%.
This is
multiplied by 2.
Lordship.
That means 30 lakhs, 30,000.
30 lakhs, 30,406.
Right. So, how can that much be awarded under the no fault?
Lordship, for no fault liabilities, it was only paid 50,000 amount. And this is the total damage cost.
So, on what basis was the award made?
Lordship, there's a provision that
What is your claim? Claim is under fault basis or no fault basis? You said no fault basis.
I have filed 2 applications. Both of them have been disposed, Lordship.
You prepare the matter, we'll list it next week then.
Lordship,
There's urgency.
there's a prayer. It may be fixed, Lordship.
That's what I'm saying, we'll fix it.
Lordship.
But you have to prepare, otherwise if you come and say that you don't know much, we'll adjourn it to a very long future date.
Lordship, kindly may list after 3 weeks.
No, rejected. See, you just heard what he said. One has already expired, one is very old now. And we don't know what will happen in the future. So you ask your senior counsel to come and argue the matter.
Lordship, leading counsel is in health issue, so.
Then you argue, you prepare and argue. We'll not adjourn it for a long date. You prepare by next week. What is your good name?
Dirilung. Dusurilung.
D.
Dusurilung. Dirilung. RILLUNG.
Okay, Miss D. Rilung, RILLUNG. Appearing on behalf of Mr.
Skip.
H.P. Phukan,
Pukon. HP Pukon.
learned counsel for the appellant, submits that the appellant is not agreeable to refer the matter for mediation. Stop. Learned counsel for the respondents. Your good name?
T. Tatak.
T. Tatak submits that. In fact, during the pendency of this appeal, one of the claimants have expired, and the other respondent is in an advanced age, and therefore the matter may be heard on priority basis. Next para, considering the above submission, let the matter be listed. Has it been admitted? Was it admitted at any point of time?
Lordship. Yes.
When? Yes, admitted. Let the matter be listed for hearing on 23rd of March. Call.
Item number 22.
Deeply obliged.
Well, I'm sorry, my lords. May I mention, my lord, if my lords permit me? If my lords permit me, may I mention, my lords? Item 14 and 15.
CRP.
Item 14 and 15.
Referred for mediation.
I want it to be adjourned.
I'm appearing on behalf of Vedanta Kosik.
On behalf of?
Vedanta Kosik, the leading counsel for the petitioner.
No, I'm mentioning some other
Vedanta
item.
Kosik.
My lord,
Yes. What do you say?
We are ready, Your Honor.
You're ready for referring the matter?
Yes.
Then who is appearing for the other side?
There's no one appearing today.
Have they appeared earlier?
Earlier, yes. It's only last occasion they appeared.
Who appeared?
Respondents.
1 and 2. How many respondents?
Were represented by
GT Sangam.
Yes, Your Honor.
Sangma. GT Sangma.
GT Sangma.
GT Sangma. How many respondents are there?
2.
2 respondents.
Since Your Honor, they are not present, so I am ready, but do they have to give their consent also?
Although the petitioners are represented by their appointed counsel, the respondents are not represented today. Accordingly, release the matter after a week under the same column. That is for referral to the special mediation drive.
Your Honor,
Dash mediation for the nation.
interim order may be continued.
When was it passed?
On the motion there itself. On 23/10.
Okay. Interim order passed shall continue till the next date of listing.
All right.
Item number 23.
No one there for the petitioner.
No.
Miss Dungan has not come today.
Mr.
Nikita?
K. Lolan is appearing for the petitioner, Your Lordship.
Sorry?
Mr. K. Lolan is appearing for the petitioner, Your Lordship.
Where is he? There are so many of them.
Yes, Your Lordship.
Nikita Dungan, Oya Perme, K. Lolen, Tate Tatuk. Nobody is there.
Your Lordship, I'm afraid, Your Lordship.
8 counsels are there. None appears for the petitioner when the matter is called. Although Mr.
Wairam, Your Lordship.
Wairam is Learned State Council. Learned State Council, right?
Yes, Your Lordship.
Is present. What is the matter regarding?
Eviction, they are challenging eviction order, Your Lordship.
Okay, list the matter again after a week. Under the column. That one, no? For referral and so on. So it's in the cost list.
Obliged, Your Lordship.
So we come back in 5 minutes and we'll take up the Pathar matter.
Lordship, Mr. S.B. Raju will mention. Mr. S.B. Raju, ASG will mention.
Who will mention what?
ASG, item number 14.
My lord, may I mention, my lord, may I mention, am I audible, my lords? Am I audible? Well, I want to mention item number 14 and 15. Item 14
private
and
respondent
15.
in this case, my lord.
Things are not ready.
I think
want
he's
time.
mute. Mr. Raju, you are mute, I think. AG is appearing in this case. For the petitioner NSPC, my lord.
My lord, in
why
this
are you
matter,
mentioning now?
No, the matter has come up because there is a direct.
Don't mention now. We're taking a part on matter.
Yes, no, I have no problem for me, my lord. I am for
I'm
the, I am
only
waiting,
asking for
since I am
adjournment.
waiting
I'm
here
asking
itself,
for
my lord.
adjournment.
But my learned friend is saying that my learned friend.
This is not the time to mention, Mr. Counsel.
Very well, I'm sorry.
Either you mention at 10:30 or you mention at 2.
Okay.
Not now in between.
Okay, my lord, it is not that I mentioned, my lord. I am sitting here, my lord.
No, but ultimately, what you want adjournment?
I don't know, lordship. Mr. ASG will.
Yes.
Please mute.
Please unmute yourself. You are on mute. We can't hear you.
I want an adjournment because they've, some of them have
No,
filed a
not
reply,
yet.
I have filed a reply, and meetings are not complete.
We can't hear you.
Am I now audible, Manoj? Am I audible now? I only want a date, short date. I only want a short date, Manoj. I've
Is it
unmuted
from
myself.
this side or that side? That side.
No, it's not from my.
You be in touch
from
with
that-
him. Okay.
Okay.
You be in touch with him. Whatever you want to say, you can say later on. Now you call item 4.
Item number 4.
Madam, on that day, I had finished my argument, madam. You have finished your argument? Yes, my lord. Only just to refresh, my lord. 2 points urged by the petitioner that the appointments of the private respondents were. Give me the file. Appointments of private respondents were illegal, not through any selection process. That my contention was that there has been enough delay in laches in challenging their appointment because their appointment was done in 2003. They have filed this writ petition challenging the appointment in 2023, after 20 years. There has been.
They means there's only one petitioner.
Yes, my lord. He has challenged it only in the year 2023. Initial appointment of private respondent number 4 was in 2003. And in between, my lord, the private respondents, they were already regularized in the year 2005. He was appointed in 2009. That time also he never challenged. He had given an objection in 2015 to the provisional seniority list also, saying that these are illegal appointees, serial number 1 to 17. But he never approached this honorable court, challenged their appointments at that point of time also. In 2015 also, he never approached. Now, just because he have been reverted from the post of ASSO, which he gained due to an unfair illegal DPC, whereby he only was considered. Now, when he has been reverted, now he has taken up, challenged.
Okay.
That is on delay and laches. And my lord, the second leg of argument that he should not have been reverted back after 7 years of being in.
He is not yet reverted, isn't it? Only a decision is taken.
Only
the DPC met.
Yes.
Order has not been issued.
Yes.
In the meantime, he came and there's a stay order.
And my lord has seen how his the DPC was has considered his promotion as ASS. So only his case was considered.
Okay. See, let me just ask you a few questions.
Yes.
The post of SK.
SK.
Is it equivalent to surveyor?
No, my lord. Surveyor is another.
It's a higher post or lower post?
Higher post.
Surveyor is a higher post.
Higher post.
So SK is lower.
Lower.
After surveyor, then what comes?
After surveyor, then SSO.
Now, earlier it is not a
table
plain tabular, my lord.
Plain
after surveyor.
Yes, now it is designated as ASSO.
Just a minute. After surveyor, it's plan tabular.
Yes.
Plain tabular.
Now
Which is
ASSO.
designated as ASSO.
Yes.
ma'am.
Then thereafter comes
the DLRSO.
DLRSO.
Yes.
So petitioner was SK.
SK.
Then he was considered for promotion to ASSO.
ASSO.
Why was there jumping over a surveyor post?
There were no qualified surveyors.
What does the rule say?
It has to be from amongst the surveyors.
Including SK?
No.
No, madam.
Not including SK.
Okay.
From surveyor, and that too by seniority come merit.
Which rule is that?
That is ASSO that
1986, my lord. Yes. Rule is there.
Let us see that rule.
Yes, ma'am. Which page 80.
Rule of SK.
No, my lord. Plain tabular, my lord. You see
Okay,
page.
first of all, let's come to SK. Please come to page 50, annexure 1.
Yes.
SK. This is also 1986.
Yes, my lord.
And it says that SK can be filled up. It's a selection post for direct recruitment, non-selection for promotion.
Yes, ma'am.
Promotion from whom? Which post?
Mandals.
Mandals having 3 years.
Yes, madam.
Continuous service in the grade, and also having passing recorder course.
Yes, ma'am.
So 50% promotion, 50% direct.
Direct.
Then next post comes
the surveyor. Surveyor, they have not.
Surveyor.
My lord, sir.
What is the next post?
It's
there is no.
There is.
My lord, there's no RR at all. But in their record also, government have said that there's no RR for for surveyor, right? Surveyor there.
Yes, sir.
So there's a, in between there's a intermediate post.
Recruitment rule has not been annexed here.
Okay, what is annexure 6 then? Page 66.
Page 66.
Supervisor.
It is the latest amendment of supervisor in Kanur 2008, my lord. It is the latest RR recruitment.
What is the difference? What has been amended?
Amended, my lord, will be
only
The
My
column
lord,
12, earlier
it was education
years.
qualification 3, education qualification class 10 matriculation, and the subsequent, my lord, latest 2008, my lord, it is education qualification is
graduation.
The graduation.
Graduation.
And also, my lord, the other, my lord.
When did you come? When did you come in the picture? 2000?
2009, my lord.
9.
Yes.
After this amendment.
Yes, my lord.
After amendment.
Yes, my lord.
Okay, now that rule of surveyor is not there.
Yes, madam.
SK is there. The amendment is there. Then what other rules is there?
Then the plain tableau.
ASSO.
Plain tableau is at page.
My lord,
That my lord will find the type
Page
copy.
one,
Page
one.
111.
111. Tabler.
Yes.
Tabler. Plain tabler. Okay, now plain tabler is a group C, non-ministerial. Then
Yes.
how
And
you
at
can
column
enter is
11,
promotion from surveyor.
survey
5 years.
5 years qualifying service.
And
In-
plain
in
tabler
the
has become ASSO.
Yes, my lord.
Yes.
ASSO. 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 Where's that? This designation of ASSO.
That will my lord.
Yes, page 105.
105.
Plain tabler to SSO.
Yes, madam.
Now, ASSO was filled up by the petitioner.
Yes, madam.
Now, how did he fill up from the post of SK?
Yes, my lord. That exactly that's
Post of SK, my lord.
yes.
Post of SK is through selection process, my lord. As per earlier rule, my lord. Even
No. You're not on the feeder post. How come you jump
Yes,
to the
my lord. In
ASSO?
fact, the note sheet at page 120 also suggested page 120.
Now,
This is the how on his representation there was a note. The file was initiated on his representation. For my lord will kindly see the representation of Sri NH Nabam so and so SK UPR.
no, he may ask for all the posts,
Yes,
even for
Here-
DLRSO.
Here the observation also.
Region is, my lord, loud and clear, my lord, in this.
Let me. In so far in para 3 at page 120, if my lord will see. In so far RR of the post is concerned, the post of PT now ASSO is 100% promotion from surveyor of.
You're reading from
page 120, para 3. The
representation.
No, my lord.
yes, that is
120.
that is a file noting. File noting, that is a type copy of the
Page 123.
120, my lord.
120.
120.
Yes, para 3.
File noting by whom?
File
By the
noting by the
department.
department.
Okay. Insofar as, please read.
Insofar as so far RR of the post is concerned, the post of PT now ASSO is 100% promotion from surveyor of the department. RR place at so and so. However, it may be informed that the PT post has been re-designated as ASSO to assist DLRSO in day-to-day field and office work which requires a person capable of dealing with field as well as on office work in tandem with DLRSO. In this connection, it may be also be informed that the maximum education qualification among the serving surveyor is class 10 pass only. Therefore, it is a fit case for one-time relaxation of RR to absorb a capable of official from among senior SKs. The seniority list is placed at page so and so.
This is noticed by whom?
This is noted by the department. Manoj file
Which
noted by
department?
the department file noting. Now,
Land management.
land management.
Land management department.
Yes, ma'am.
Ultimately, while this is in the noting, it happened that only one person was considered.
Yes, my lord.
That
Only
is your
one-
case.
That only one. Even in this noting also, they have clearly mentioned it is from the post of surveyor, and from the there should be a relaxation of the RR, so as to absorb capable officials from among senior SKs. But these also, no senior SKs were considered. Only his case was considered. And he was given, since the post fell vacant due to retirement, this lone post was filled up by him.
Okay, why relaxation was required?
The relaxation that
because the surveyor was only graduate, were only class 10 pass.
Yes, surveyor was the feeder cater to fill up the post of ASSO, but there were no qualified surveyors. So from senior most SKs, it was to be filled up. But that relaxation also was not done. But SK only his case was considered. The petitioner's case was considered, although he was far below in the seniority list.
I see the note.
Yes.
What is the purport of this note? It says that maximum education qualifications among serving surveyors is class 10 pass only.
Yeah.
So, in order to accommodate as surveyors, then the one-time relaxation is required. If that was the noting, I understand.
Yes.
But instead of that, it goes now to a different line.
Different line.
See, therefore, it is a fit case for one-time relaxation of RR to absorb capable official from amongst
senior SKs.
Surveyors. It should have been surveyors. Now it says SKs.
SKs.
Because there's no surveyor, madam. There's no surveyor in the department, madam.
Either it should have been the relaxation for the education qualification of the surveyors, or directly that it should have been said that.
These are two things.
Two things.
Mr. Ratan.
Yes.
One is that surveyor is only class 10 pass.
Yes.
So since there is no graduate, since graduate is required for SSO, one-time relaxation for their educational qualifications is required.
Of the surveyors.
This is one point. The other point is that even SKs also should be given a chance.
Yes. But none of that was done.
So the thing that surveyors are only class 10 was how it started, but the end is something else.
Yes, ma'am.
The ending part, it says that now senior SKs should be.
Yes. None of the, either relaxation should have been given to the surveyors of their education qualification, or the RR should have been amended, even including the SKs. RR should have been relaxed. But none of these two has been done. Instead, the petitioner has been directly given officiating promotion. And
Where's
then
the officiating promotion? Officiating promotion.
My lord, madam, my officiating promotion.
At page 123.
123.
Yes, ma'am.
Officiating means officiating.
Yes.
Isn't it?
Yes,
ma'am.
Thereafter,
right
he has been
continue.
regularized.
You have no right to regularization.
Yes, but he has been regularized by a subsequent DPC.
Correct. So DPC came, then the DPC now says, DP says that 131, is it?
130, 131 is the type
copy.
Yes, ma'am. 123 is his officiating promotion as ASSO, and that is in 2nd February 2016, and thereafter within a period of 10 months he has been regularized.
So let us see what is the reasoning given. These are your officials only.
Yes.
Land management secretary is there, director of land management is there, under secretary PNR is also there.
Yes. Now this has.
It is not that the petitioner promoted himself.
Yes, ma'am.
It is your officials only.
Yes.
Let us see what reasoning they have given.
Yes, my lord. My lord will.
Department has placed all relevant documents.
Yes. Department has placed all the relevant documents pertaining to the post of ASSO plan tabler. As per materials produced by the department, the lone post of ASSO is lying vacant following retirement of Sri Gope Kamdak, who retired on attainment of superannuation from ASSO on 29 February 2016. And one Sri Nakap Hina Navam has been appointed on officiating basis in the post in the resultant vacancy. DPC is to examine the service books, ACRs, and other relevant records of Nakap Hina Navam with proposal to promote him to the post of ASSO and also to regularize his officiating service in the pay band of so and so, so and so. The DPC has examined all the required particulars of the incumbent relating to the ACRs, APARs, dossiers, NOC, vigilance clearance, and are found to be in order except seniority list
since Sri Nakap Hina Nabam was already officiating in the post of ASO and his name has been taken out, omitted from the seniority list of supervision Kanungo SK by the department. So and so, the DPC found Sri so and so.
That was his substantive post.
SK was my substantive post.
See, that's what I'm saying.
SK
Although you may be officiating,
yes,
in the as ASSO, or let's say for that matter, this post, what do you call it? The
plan tabler.
Plan tabler. You're officiating as plan tabler on officiating basis.
Yes.
But your substantive post is
Is
SK.
there SK?
So why should his name be deleted from that list? It should not have been deleted.
It should not have been deleted.
It should have remained.
Yes. It should not have been deleted because when the final seniority list was, he was already as an ASSO. But in
No, he was still on officiating
yes,
basis.
yes, my lord.
It's not that DPC has regularized.
Yes.
Yet to regularize.
Yet to regularize. These were the mistakes committed by the department. They have come to realize it. Yes, this DPC should have considered the senior most SKs if allowed by relaxation of rules. Or
Where is the relaxation? Any relaxation?
no
happened?
relaxation.
Then
no relaxation was good. Now this is the very DPC which has been reviewed. That this DPC was bad. So and his promotion, the petitioner's promotion to the post of ASSO was bad. That's why by the subsequent review DPC, he has been reverted back.
see the reasoning given here. They say the post is lying vacant because somebody retired.
Yes.
So somebody
he was officiating.
petition has been kept as officiating.
Yes.
Now, how he has come to that zone of consideration has not been explained.
Not explained.
It just goes ahead saying that he has been
Yes,
officiating.
because he was officiating.
He's already officiating.
Yes.
So now we are to examine his service records.
Yes.
Whether relaxation is done or not required, that is silent.
Silent.
Correct. So that has not been done.
This was not, therefore there was flaws in this DPC recommendation whereby his promotion was regularized. So this DPC recommendation of the petitioner has been reviewed. That no, his case should not have been considered at that point of time.
Okay, now let me jump up to something else.
Yes.
As per the recruitment rules in vogue now, senior SKs can be promoted to the post of DLRSO,
Yes.
having at least 15 years.
15 years.
Correct.
Yes.
And others also are there, 10 years, 5 years, 8 years, like that. So senior things are there. So they have been recommended. I think the private respondents have been recommended.
And
so that is the issue now.
If considering him as the SK, he was appointed in the year 2009 as an SK. He is still not qualified. He has not completed 15 years of service as an SK.
Now, if this appointment, if his promotion or confirmation as the SS goes, then he's not qualified.
He's not qualified.
Question is that since the DPC has recommended his name in way back in 2016,
yes,
can it be reopened at this stage?
Yes, my lord. To my humble
that point you satisfied?
Yes, to my respectful submission, my lord. Even in the our affidavit we have shown, when there was materials not placed before the DPC for at the time of consideration, when there was some mistakes in the DPC, that can always be reviewed. Because at that point of time, my lord has kindly seen.
But when can it be reviewed?
My lord, when
supposing person has retired already, will you call him back?
No, my lord,
that wrongly promoted to this post. You should have been promoted. So hence we demote you again, and your pension emoluments also will be lesser. Can you do that like that?
No, my lord. Oh, what?
To what extent can you go? I mean, as far back as how many years can you go back to review that thing? You are banking upon certain guidelines, saying that if there's some mistake,
yes, ma'am,
definitely we can do it.
Yes, ma'am.
But since you are before the court,
yes,
we are also to see whether justice is done or not.
Yes, yes.
Person has enjoyed this 7-8 years.
Yes, ma'am.
Can you drag him back to that stage again?
Well, so long as this continues, his illegal promotion continues to hamper the rights of others, my lord, in that event, my respectful submission will be that the DPC will, at any distant point of time also, the DPC will be at the, have the power to review. Because it is a continuing process, it is a continuing illegality which is hampering the promotional avenues of others, the others' right. Had it been a case, his case, without hampering any other person's right, then the review DPC at a distant point of time would not have been justified. But since his illegal promotion is continuing and is having an effect adverse to his seniors, my respectful submission that illegality cannot be allowed to continue further, and that the government will obviously have the discretion to correct what mistake they have committed. That my respectful submission.
You had given some citation.
Yes,
is it in support of that submission?
That I have given two citations in respect of the delay and laches in challenging the initial appointment of the private delay and laches for challenging the appointments of the private respondent after a lapse of 20 years. That is there. The second citation is that
DPC.
Second citation is for the fact that even while this DPC, which had given him the promotion, regularization of his officiating, that time also being seniors, they were required to be considered. That citation is there. The second citation is that the seniority has to always be considered. It is even if
others would have also been considered.
Yes,
that's what it's saying.
That for that only purpose. That even during 2016 seniority should have been considered.
But have you undertaken any exercise of relaxation?
No relaxation. That's why nothing. Only this.
So that means neither surveyors nor SKs are eligible to be considered.
Yes, for the post of ASSO.
That noting said that they are only the present
Exactly.
Surveyors are only class 10 pass.
Yes.
So the rules otherwise says that one has to be a graduate.
Graduate.
So in order to make the surveyors eligible, the rules have to be relaxed. Their educational qualification has to be relaxed. And in order to make the SKs eligible, the rules again has to be relaxed.
Again has to be amended or incorporating the SKs
and you also say that there is no recruitment rules for the assistant survey. What is that? SSO? Assistant Survey and Settlement Officer.
Settlement Officer.
There is no rules, you say. But if there is no rules, you can go for the rules of PT. That what is that?
Yes.
Plain tabular. Same thing.
Same thing.
Plain tabular.
Yes.
Same thing.
That's why. Plain tabular. Or otherwise, after it being converted into a Group B post, a separate order should have been framed. After re-designation.
And petitioner, of course, he will definitely want to get promoted. One person has now retired on superannuation, so there is nobody. Let me apply. He applied, and he also gave him.
That is the mistake we have committed.
All the quorum was there, the secretary was there, the director was there, under secretary from PNR also was there.
That is how.
But all of them are silent, saying that why we are considering him only because of relaxation. Nothing is there.
Only the thing is that because he was already officiating. That is the only reason. Because he has been.
But like I said, even if you're officiating, okay, you're well and good, you can officiate, no doubt. But your lien goes to their original post. SK.
Yes, ma'am.
Your seniority cannot be wiped out from there.
In fact, what we can see from this DPC is that only for the reason that he has been allowed on officiating basis, the seniors SKs were completely forgotten.
They also forgot about him. I'll ask that to Mr. Parra.
So that review DPC was, and whatever mistake was done, that has been corrected now. The petitioner also, in his turn, he will also be considered for promotion. when his turn, when the vacancy arises, and when his turn comes. Why try to have a merge over by taking advantage over illegal DPC, which he ought not to have been given the promotion? That is my submission.
Okay, let me hear Mr. Tara.
Yes, ma'am.
In the meantime, if you have any citation regarding the DPC
review
can go back in time and
Yes.
correct the rectification. Any citation, you tell me?
I have the answer.
Okay.
No, just I was noting down something in the course of interactions between learned AG and the bench. I said, it came to my mind to note down this. He who seeks equity must do equity. The petitioner has done neither in this case. Now, as far as this particular, when this DPC can be reviewed, my lord, the answer, my lord, will find it is in the General Clause Act, 1897, 14 and 21. Power to issue and power to rescind, my lord.
General Clauses Act.
That it came to my mind. If there is extra copy, like I just not brought it.
That is a book stand up there on the side. What books are they? No, here, behind the calendar. Just take away the calendar. Table calendar. Oh, that book. That can be kept here later on. Sure, we can just pull up from here. Not now.
But if I correctly remember, my memory goes.
Which one?
Section 14 and 21. Power to issue and power to rescind, power to appoint and power to revoke.
14 onwards.
14 and 21, if my memory is correct.
See, Minister, it's okay. I will keep there. But FRSR normally will not be that. But the barracks we should have out here.
Okay. 1975.
14.
14. Kindly say.
Conferred to be exercised from time to time.
Correct.
This one. You have a book with you?
No, just it came to my mind. I forgot to bring 14 and 21. I correctly remember the power to issue and power to rescind is in 21.
Power to issue to include power to add, to amend, vary or assign notifications, order rules or bylaws.
Correct. Any rules, whether it is statutory or just a general rule,
Okay.
The answer. Then, my lord, what happens is in every recruitment rule, my lord will find the government is always vested with the power to remove the difficulty, my lord.
You're for respondent number?
4, my lord.
4. Okay. Okay. Remove difficulties.
Remove difficulties, my lord. That, my lord, I have one old citation on this.
But how do you apply that and remove difficulties? This is a review. I mean, this is a DPC which happened 6-7 years back.
No, my lord. It will come into because there is a continuous illegality and that cannot be allowed to perpetuate, my lord. The moment it has come to the notice of the state government has a power to remove the difficulty and place a person to a particular place where he was. Well, that I have one on this exactly. I was searching for that judgment, but I could not get it. But still, I have one judgment on this, my lord. On the principle that power to remove the difficulty, my lord. 1975, 3 SCC 765.
1975, 3 SCC.
765. Para 40, my lord.
40.
Yes, my lord. This two exactly, my lord, the government has been empowered to do with this, my lord. The fact of this case was interpreting the
income tax law, well, there was some difficulty in it, and accordingly, whether the government has the power to remove difficulty or not. Now, my lord, just para 40 straight, we are coming. Now, let us turn to clause 7 of the regulation. It will be seen that the power given by it is not uncontrolled or unfettered. It is strictly circumscribed, and its use is conditioned and restricted. The existence or arising of a difficulty is sine qua non for the exercise of power. If this condition precedent is not satisfied as an objective fact, the power under this clause cannot be invoked at all. Again, the difficulty contemplated by the clause must be a difficulty arising in giving effect to the provision of the Act, and not difficulty arising alienate or an extraneous difficulty. Now here, my lord, the objective and the definition given under Section 20 of the General Clause Act will come into effect, my lord. So the government has an unfettered power in case of any difficulty, any discrepancy that finds, can always invoke this power. And my lord, appropriately, my lord, kindly come to page 167, how his DPC was. These aspect 167, my lord.
Paragraph 1 to 6. This one?
Yeah, 168 is a type copy, my lord, in the read petition. My lord, this is the crux of the issue which my lord has, the question has fallen to the learned additional AG, and learned additional AG just skipped over this. Maybe he has not forgot.
He's left it for you.
Yeah, I agree. My lord, type copy is this, my lord. The reasoning why his ASO was to be recalled, a promotion given. The DPC found, my lord, I am reading from this. The DPC found Sri Nakab Hina Nawam to be fit for promotion and regularization from the date of officiating promotion in view of the doctrine of continuous officiating under Article 309 of the Constitution of India. When the matter came up for subsequent promotion from ASO to DLSO, the following discrepancies were found in case of promotion to the post of ASSO. One, my lord, there was one vacant post, and therefore the zone of consideration was 1:4, and therefore 4 officers ought to have been considered based on their seniority and eligibility. However, the DPC considered only one case. But this is the first lapse, because the seniority of the SKs who were born in the cadre before him was not considered. So therefore, the first, my lord, the DPC where he was considered, prima facie, there was a discrepancy, and accordingly the DPC has recorded it, my lord, and that is their finding. Number 2, my lord, on perusal of the draft seniority list, surveyor stroke SK stroke RK of the department dated 15/10/2015, it was found that the officer considered for promotion was listed at seniority number 21. There were 20 senior officers, my lord, that I will also look up, and I'll demonstrate from the annexures, my lord. Officers before him. In final seniority list, which was issued on 5/5/2016, it was found that the officer's name has been omitted without assigning any reason. That is what my lord has also put a question to the learned additional AG. Because at the time of consideration of his promotion to the ASO, there was no seniority and his name was struck out. So therefore, he was not there. He was ASO, that's why his name was not there in the senior of the SK, my lord.
That we have seen yesterday also.
Yes.
He is the only one in the ASSO list.
Correct.
Only one person.
This is butting in, my lord, just adding to that.
Sure.
Okay. Well, just I complete that. The senior most SK above him were found listed in the final seniority list as per proposed draft referred to earlier, my lord. 3, my lord, on perusal of the service particulars of the officer senior to the officer considered for promotion, it was found that the officers fulfill the service requirement, my lord.
The post of ASSO was created, stroke redesignated newly, and no RR has been framed. Therefore, regular promotion could not be granted from SK to ASSO. So this is the reasoning. And this reasoning, my lord, I find is factually correct, legally sound, my lord. Number 5, the redesignated post was earlier called plan tabular, and the promotion to the post of plain tabular was through surveyor, and there was no provision for promotion to plain tabular from SK stroke RK post, my lord. 6, my lord. Even if the DPC decided to consider the SK stroke RK to the redesignated post of ASO without RR, it should have gone by the zone of consideration and seniority. Correct, my lord? My lord, I've seen there are so many senior people. He has merged over 20 SK who are senior to him, and that is prima facie and illegality, my lord. My brother, the counsel for the petitioner, Mr. Tagum, relied on so many judgments. While flipping through those judgments, these ratios which he relied on, Uma Devi and all, these are tacitly applicable against him only, my lord. It should have gone by the zone of consideration and seniority with both criteria being considered. The said officers could not have been promoted as ASO either on officiating basis or on regular basis. And this is the reasoning, my lord.
I've seen it. Mr. Tara, can you explain this point number 3? What is your understanding?
On perusal of the service particulars of the officer senior to the officer considered for promotion, it was found that officer fulfilled the service requirement.
Which officers?
That is ambiguity.
Which officers?
It is two. It is
including the private respondents.
Including the private respondents.
And
that's why.
No, how do you say that? As per the service particulars, they have found that officers fulfilled the service requirements.
This is offshoot of number 2, Milord.
No, how do you say they have?
No, Milord, this is the offshoot of number 2. So they have made these as a...
No, admittedly, you were surveyor. No, I'm sorry, you were also SK.
SK.
From SK, there was no provision for promotion to ASSO.
We are not claiming on that.
No, this paragraph 3 says that on perusal of the service particulars of officers senior to the officer considered for promotion. That means while considering the other seniors to the petitioner,
now
it was found that the officers fulfilled the service requirement. How did you fulfill?
While bowing down, my lord.
Nobody fulfilled.
While bowing down, my lord, my clarification is to the query that has fallen. We are claiming on the basis of ASO, not from the SK. We were SK.
You are still SK.
You are SK. And qualifying service is 15 years.
Yes, yes. Well, that I'll come.
You are still SK. You have minimum 15 years.
I stand corrected. So that means, from SK, the qualifying period for promotion to the DLRSO is 15 years. And in the case of this petitioner, hasn't met this criteria. So that
if he is considered as SK.
As SK.
But if he is considered as ASSO,
even then also 2.5 years.
5 years, man. 5 years. ASO, I'm more than 7 years. Man. 5 years.
No, he's right.
Yes.
See, if his ASSO post is upheld, he has got 7 years.
His
requirement is 5 years.
Yes, man. His appointment, the German of his appointment is illegal as an AS.
That's the other aspect, illegal. Supposing it is not illegal,
correct.
He has the service. So question is that whether we can go back in time to correct that mistake.
That is, I have answered, my lord, in my. So therefore, my lord, now I come to this. The second limb of my argument, my lord, will stand. There, I'll come to this. My lord, the second limb of my argument would be the petition is barred by leches, accusations, and settled seniority. My lord. Now, my lord, kindly see the petitioner challenge to the 2005 regularization of respondent number 4 and subsequent seniority list is legally impermissible due to gross delay and decade of silence acceptance by them. And this, my lord, will find at page Annexure 12, my lord, page 55. Page 85, sorry, my lord.
This is seniority. What is this? 85?
Seniority list.
Provisional.
Provisional seniority.
He's junior to you all.
Correct.
You are all senior.
Correct. So therefore, in that, my lord has seen that page 167. Clearly, it is written that he was junior to us in the SK. I'm paraphrasing and shortening my argument, my lord. That is second thing, my lord, in the seniority list dated 22/5/2022, respondent number 4, my lord, that my lord will find at serial number 9. Page 89, my lord, will come.
Just a minute.
Page 89.
Mm. 89.
Page annexure 13. First, my lord will come to page 85 and 88.
These are the seniority lists.
Yes, that's my lord. I am
on 2 occasions.
Yes.
There was no complaint.
There was no complaint. That is the
So
way.
matter settled.
That is the way.
But he has been taken out from there and kept as SSO.
Correct, but I'll
And-
answer to that also. Now, my lord, kindly see. Now, seniority list dated 1510. Next page, my lord, will find. Page 89, my lord.
Yes.
There, page 89, my lord, kindly see. Here, in page, I stands at serial number 7, page 90, my lord, page 90. I stands at serial number 7.
7.
And the petitioner, serial number is
21.
21. And these, my lord, these remained unchallenged for 8 years. Now, there is a judgment by the apex court, my lord, in 2022, Murugan case, my lord. Now, to my understanding is, my lord, the petitioner's silence constitutes accusance, waiver, and it is estoppel. You cannot claim this seniority, my lord. So then, my lord, kindly, I have these citations with me. 2022, 2 SSC, page 25. My lord. It starts from paragraph 20 to 36, my lord. It's all waiver, estoppel, accusance, my lord, everything is given, my lord. And, my lord, kindly see next 2010 judgment you also simultaneously. My lord. My lord, these are all settled principles, just I'm indicating the paragraph.
Yes, yes. I have noted it.
Yes. Then, my lord,
you need not read.
yes. My lord, one more point, one more very important judgment is 2010 4 SSC 301, my lord. But the HS one key, my lord. Here, I'll just one paragraph.
This is also on delay in latches.
Yes, my lord. Now, here, my lord, two things. One, in a read proceedings, maximum delay a person can take is not more than 3 years. And here is a case that 8 years has gone and he has not dared to challenge it, my lord. My lord, at 2 we will resume, my lord. Paragraph 38 and this thing, my lord.
39.
39, my lord. My lord, this one line, my lord. Anyway, I'll not. I'll just.
The other case regarding Murugan. Murugesan is para 25. No, para. You said paragraph 20 to 26.
20 to 26, my lord.
Out here is in 25. That's why I got confused.
Sorry, my lord.
20 to 25.
20 to
26, sorry. 20 to 26.
But this is the most beautiful judgment on the all the waiver, accusance, stop.
Okay.
I'll come back to that.
Come back.
What's it mentioned for item number 14? ASG will appear through RBC.
Yes.
Yes.
My lord, in this matter, am I audible, my lords?
Yes.
Can my lords
Yeah,
hear
yeah.
me?
Yes, loud and clear.
Yeah, thank you, my lord. Now, this matter, the pleadings are not complete. Only 2 or 3 respondents have filed their affidavit. We have to file a rejoinder to it. And therefore, some time may be given and let the pleadings be complete. And we have already deposited the amount as per the terms of the order, dated 18th of February 26, 48 crores and odd has been deposited.
When do you want it?
Anytime convenient to my lords after.
After?
My lord, I am appearing in this case, my lord.
Just a minute. After you want it after which, how much, when?
After the vacation, my lord.
Vacation means the, what, Bihu? April?
Yes, April will be fine.
Second weekend.
April 3rd week
Okay, fine, my lords. Fine.
is the vacation, yeah, 1 week. No. Okay.
So if it is not inconvenient, let them complete. Affidavit has been filed before this date. Today was the date fixed, so we filed it. The matter was moved. So can it be on 23rd of March? Because the problem is with the landowners, my lord. There is a contempt which is pending, my lord. Contempt also has been pending. Now a writ petition has been filed. There is no
Nothing
stay
otherwise
in the
now
writ
I
petition.
demonstrated last time.
Now they have there is an order passed by this court that if your lordship see the last order, see the last order that has been passed by this court.
No, you come to a consensus on a date.
No, that's let it be on 23rd. 23rd of March, if it is not incoming to my learned friend. In the meantime, the contempt application also can be taken up on that day, my lord.
Yes, Mr. Paul, Raju.
23rd.
23rd is all right.
That's a Monday.
Monday.
23rd March.
Yes.
Is it convenient?
Yes, my lord, it's convenient.
All right, we'll fix it accordingly then. Any matter to be fixed on this date apart from this? Oh, it's already there. Contempt 15.
Contempt, yes.
This is the one you're talking
May I
about.
request
along
second half,
Okay.
23rd, second half.
Let this
23rd,
matter be.
second half.
Second half. The
Second
morning
half.
somebody can.
First of
Morning
Depends on
somebody
that
can.
Somebody has to make.
I'll not reflect that in the order.
Yes, yes.
Morning
Don't
somebody should, because I'll not be, perhaps not be sitting on that day. Otherwise I could have given that observation. But when somebody is going to sit there instead of me, then it will not be fair on my part to fix a time.
Yeah, I will make a mention.
All right. All right.
So there are two. One is writ petition 58. They have filed it, and we also file a contempt. So let this matter come together. In persons, the court's order they have deposited. They are deposited. We'll try to argue this matter that they should release to us. That's the whole problem. He can argue on this point.
Please write. Parties are represented by the respective councils and they submit that the matter may be posted for consideration on 23rd of March 2026. Stop. Mr. S.V. Raju. Learned Additional Solicitor General submits that a deposit has been made before the registry of this court in terms of the last court's order. Full stop.
Correspondence we have filed our We have filed our state response.
Mr. N. Ratan, Learned Additional AG, appearing for the state respondents, submit that the state respondents have already filed their counter affidavit. Mr. D. Das, Learned Senior Counsel, appearing for the
private respondent number.
Private respondent number
5 to 13.
5 to 13 submits that since the deposit has been made as directed by this court, the private respondents would be seeking withdrawal of the same in the next court date.
And we have also filed, we have filed IA 320 of 2025.
When 3 have not filed.
IA C 320 of 2025. 320 of 2015.
It's not listed
2025.
today?
It is listed.
Okay, okay.
Yes, along with that.
This IA is for withdrawal.
Yes, for that, yes. To disburse the amount to
And
us.
for which the interlocutory application IAC number 320 of 2025 has been filed.
We
Stop
file a
data
reply to
right?
that, and we want to file a rejoinder. Reply and rejoinder both time may be given. We may be permitted to file a reply to the IA as well as a rejoinder to the affidavit.
Surely.
IA file ko reason
Be that as it may, since parties have agreed,
Objection they have filed, I think. My learned friend has not. Objection has been filed. In 320, they have filed an objection. Objection has been filed by NSPC, my lord. That has been filed. My lord, it is.
Okay.
It is has been filed on 28th
They have
of
filed
January.
the motion, not in the main matter.
Yes, yes. 20, yes.
All right. Be
Yes,
that as
they
it
have
may,
filed.
since the parties have agreed for listing the matter on 23rd March 2026, let the matter be listed on that date. Parties are also at liberty to exchange the further pleadings if so necessary before the date.
And in the main case, 58, we filed the affidavit in our
right.
office. Yes.
Grateful.
Okay.
Deeply obliged, man.
Obliged.
May it please, Your Lordship. Lordship, kindly I may be allowed to mention item number 25, Lordship.
Yes, what do you want? 25?
Lordship, this is a tender matter and listing for hearing today. However, conducting counsel, Mr. Pangin, is some difficulties, personal difficulties.
When?
Lordship. April 6th.
6th of April, my lord.
Okay. Mr. D. Pangin, learned counsel for the petitioner, is said to have some personal difficulty to conduct the case today. Has not objected. They say, and therefore adjournment has been, and therefore a prayer for adjournment has been made. Stop. They said prayer is not opposed to by the learned counsel for the opposite party. Stop. As agreed to by the parties, let the matter be listed on 6th of April
6th of
for hearing.
My name may be kindly be recorded.
Name of
BK Singh.
Mr.
BK Singh for FCI respondent.
BK Singh.
My lord.
SC, FCI be reflected in the cost list hereafter.
Obliged, my lord.
Okay.
Obliged.
So that leaves us only to item 4. Is it so? Any other matter?
May Lordship, Lordship, I beg to mention item number 9.
9.
Yes, Lordship. Leading counsel is left out.
9, I think we have passed an order.
No, not yet. No.
Not yet.
Yeah,
Then why did?
and 9 is left.
Okay, 9 is left, right?
7 also.
So,
With the consent of other government advocates, leading counsel is due to medical emergency. So kindly, this matter may be taken about 17th.
okay, as paid for on behalf of Mr. T. Tapak, learned counsel for the petitioners and not objected to by the other side. List the matter again on 17th. List the matter on 17th. 17th March.
I'm sorry, Lordship. Lordship, in item number 25, there is an interim order, Lordship. Kindly interim order shall be continued, Lordship.
What did I say? Item 25?
25. 26.
List again on 6 April. Okay. Interim order passes shall continue till then.
Obliged.
Okay.
Yes, sorry. No, my lord, I was saying, if for last 8 years, the petitioner choose not to challenge the seniority list. To that extent, my lord, I'm referring to this authority, my lord. HS 1 key 2010 for SSC 301.
Yes.
Para 18, my lord. 38, sorry. 38 and 39, my lord. If my lord permits me, I'll.
Okay.
My lord, kindly come to para 38, my lord, placitum G, my lord. Placitum G, there's above one line. If the settled seniority at the instance of one's seniority in service is unsettled, it may generate bitterness, resentment, hostility among the government servant, and the enthusiasm to do quality work might be lost. Such a situation may drive the parties to approach the administration for resolution of that acrimonious and poison situation, which may consume a lot of time, energy. The decision either way may drive the parties to litigate willingness to the advantage of legal professionals, both and private government, driving the parties to acute penury. It is well known that the salary they earn may not match the litigation expense and so on and so forth, may not then para 8, para 39. This is the reiterating the various principle which it says the ratio settled seniority once settled shall not be unsettled. So therefore, complete acquiescence and waiver to challenge the seniority list. They are barred by this proposition of law as well, my lord.
Okay.
Now, as I said this morning, who seeks equity must do equity. Neither of has been done by the petitioner. To that extent, my lord, one must come with a clean hand. And here I find that the petitioner has at all not come with a clean hand. So this aspect is also there. Because the petitioner himself, my lord, is a beneficiary of an irregular promotion from SK, marching over many, plain tabular, and then SK, then marching over to many seniors, my lord. So that irregular, because he himself is the beneficiary of that irregular order, my lord. So therefore, a beneficiary of an irregular promotion, my lord, part and is legally stopped from challenging the R4 on similar grounds. So that, my lord, will see this annexure 17, my lord. Page 114, my lord. That is, I'm referring to in terms of, my lord, in terms of 1986 RR, my lord. Here it says, mandatorily you must have 5 years qualifying service in the grade to the seniority come merit. So here,
as surveyor.
Yes, as surveyor. And he does not have that qualifying length, my lord.
Surveyor.
SK. He does not have that qualifying length, my lord. Because I'm referring to this for a purpose, my lord. My lord will see that.
No, plain tabular is a post higher than the post of surveyor. Surveyor is a post higher than the SK.
Surveyor.
SK here.
Right, man. Right.
Surveyor here.
Yes.
Plain tabular here.
I agree with that.
So from SK, how do you connect to the what you call plain tabular, leaving aside the surveyor post? Now, what is the post? What is the rules for surveyor? Anything? Any?
That the part.
It is not here in the writ petition.
My lord, recruitment rule has not been enclosed here in the
And
case, my lord.
Surveyor, because plain tabular says that it can be filled up by surveyor having 5 years.
Because he was.
He is not a surveyor. You are also not a surveyor.
No.
You are a SK. And amongst the SKs, you are the senior one. He is the junior one. That issue is not disputed.
But the hierarchy, my lord, can find out in the RR of the LRSO.
Which says number of years.
Yes.
Where's that?
Page 140. This is the amended portion of that.
140.
Yes, I am coming to that, my lord. Because he does not have the, to my understanding, my lord, he does not have the statutory
Serial number 6.
ineligible.
Existing entries, the following will be substituted mainly by promotion from
Correct.
ASO, who has rendered 5 years of service. Then D, which will be surveyor who has rendered 11 years of regular service in the Then comes the record Kanungo and supervisor who have rendered 15 years.
Yes, 15 years for SK.
Yes.
Surveyor 11 years.
Correct.
Then ASSO 5 years.
Yes, my lord. So on this count, my lord, because that DPC dated 18/10/2022 and the DPC dated 23/6/2023, the petitioner had rendered only 13 years and 1 month, and another is 13 years, 9 months. So he was not in the zone of any consideration, even in case of ASO also, my lord. In terms of this page, which my lord has perused, is annexure 27, page 140, my lord will only mark this. So therefore, all his promotion is illegal, my lord. Therefore, the government has rightly taken a decision to review the DPC, invoking section 21 of the General Clause Act. Power to issue and power to receive.
The review has happened on which year?
Review has
25.
23, my lord.
23, my lord.
23.
Yes.
23.
Yes, my lord.
23, my lord.
Okay. 23.
After more than 7 years.
Hmm. Yes, anything else?
That's why. That's why, my lord, a person, my lord, what I understand is, his promotion is made beholds the law and does not satisfy the essential 15 years of qualification, my lord, service qualification to claim to the post is a legal nullity. It's a complete legal nullity. And the judgment which my brother relied to was, my lord, I give the judgment, my lord. It is, my lord, Pramod Kumar versus UP, my lord, Secondary Education Service Selection Board, 2008, my lord, 7 SSC, page 153, para 16 and 18.
This was cited by Mr. Tagu. Or you are citing it?
I'm citing it.
2000? 2008.
2008, my lord.
Volume?
7 SSC, page 153.
153, para?
16 and 18, my lord.
16.
And 18, my lord.
Okay. Okay.
Because, my lord, the qualification has been laid down in the RR and you cannot violate it. Violating the statutory rule, any promotion given is bad in law and is nullity, my lord.
This is on that aspect.
On that aspect.
I see. 16 and 18.
Now, below that, still like I should still rely on the power of state to correct the technical errors, my lord. That should have been the real question where we should have been questioned for. Now, my lord, kindly, my lord, have already seen the petitioner promotion to ASSO, annexure 27, my lord, page 139. Type copy is at 140. Huh? Kindly see this. And he bypassed, his promotion was on officiating basis and bypassed the rightful seniority of respondent number 4 and 5. So this is then now what the law says on this. State of West Bengal versus Anish Kumar Roy. Can you provide the judgment? No, this I am not relying on. Sorry. This is not the one. Now, in that event, my lord, while he challenges my initial appointment as illegal, that is in terms of his prayer, para number 4 and 5. He made a challenge of my initial appointment and regularization in regularization. What is, my lord, illegal and what is irregular, my lord? My lord, that I beg to refer ML Kesri judgment is a non-celebrated
ML
judgment.
Kesri.
So, I'm going to sum up, my lord, para 7 to 13, my lord. ML Kesri, the 2010 9 SSC 247, my lord. Para 7 to 13, my lord. Here it has discussed, because my lord will mark this, the Rule 7 always provides the power to the state government to relax the rule. So, once a person is appointed, my lord, as officiate, once a person, the respondent number 4 is appointed as a respondent, my lord, officiating, and thereafter, my lord, what had happened? The DPC has held. Until such time, my lord, the Uma Devi judgment has not come into force. Uma Devi judgment came only in 10th April 2006. So therefore, my lord, it is Uma Devi judgment is reported in 2006 for SSC page 1, my lord. And which the paragraph, especially paragraph 53, my lord, it made a clear distinction, my lord. And thereafter, therefore, the Mamta Mahanti judgment which my brother has relied to will not come into, my lord. And this judgment, my lord, thus
everything is clear. Para 8 is more very loud and clear in this. It has distinguished. So now, in their case, my lord, in his case, no relaxation has been obtained. Only thing they did is they initiated a file movement, my lord. So now DPC has been held, my lord, for the DLRSO, ASSO, right?
DSSO.
ASO and DLRSO also, both the DPCs.
You are a contender for DLRSO?
Yes, because I am senior to him.
No, that is there. You are saying they have initiated file for both ASSO and DLRSO?
Yes.
Are we not dealing only with DLRSO?
No, only two particular positions, my lord. Because he marched over many senior to become ASO by file noting 131.
No, what is the recommendation made in your favor now? Which is for which post?
DLRSO.
My case is for DLRSO.
That's what. Is there you are also is there also an intent to fill up ASSO post?
No.
Okay, we are only concerned with DLRSO.
Yes.
And you come from that 15 years category.
I come from that 15-year category, and there is no doubt on this. In his case, my lord, the petitioner case, my lord, even if he comes from the ASO, he is not eligible. SK. From the SK to the ASO. It's not eligible. Because it has to, because the feeder cadre for DLRSO at the time of DPC was only 2 posts were vacant, my lord. And that relevant point of time, he was not eligible. 13 years length of service.
Which post? ASO.
ASO.
DLRSO.
No, I was already promoted to the ASO, my lord.
No, that's why I made a categorical summation. Your officiating promotion, marching over 20 seniors is illegal, and you are a beneficiary of that illegal order, and you cannot claim any right here.
Okay. And that's it.
I don't have much to submit, my lord. Therefore,
But can I ask you one question?
Yes, my lord, just a conclusion line, my lord, that I want to say. The petitioner is barred by laches, is statutorily ineligible, and lacks the clean hands required to invoke this court's equitable jurisdiction.
Okay.
And therefore, my lord, conversely, my lord, our court's promotion is just, legal, and in accordance with the recruitment rules. Thus, it is humbly pray that the petition may be dismissed with a cost. So any further clarification, I am available.
Okay. I'll ask you one question also.
Yes, my lord.
You come to page 123.
123, correct. 1 second. Trade petition. 1, 2, 3. Just I go to the workplace.
It's an extra 20.
Yes, sir. Read petition, workplace 1. 1 second. My lord, which page?
123.
123. Okay, 120, yes. Annexure 19, my lord.
No, 123.
123, yes, my lord.
This is the officiating promotion.
Yes.
Of the petitioner to the post of ASSO.
Correct.
Dated 2nd February 2016.
Correct.
Which is followed by page 131.
131, yes, my lord.
This is the DPC. Who sat on 29 December 2016.
Correct.
Saying that he should be promoted on regular basis now, with effect from the date of his initial officiating appointment. That is Annexure 23, page 132. See, all these things happen in the year February to December 2016. What did the private respondents do?
We were SK. We were already in terms of...
No, you were SK. That's why you were senior to the petitioner.
Yes.
Then what did you do? You said, how come he was promoted? We are senior.
Either grade promotion was? To the DLRSO.
DLRSO, yes.
SK, from SK, the feeder grade is DLRSO.
No, see, going by that provisional list, 2 provisional lists are there.
Yes.
You are ahead of the ahead of the petitioner in position in the seniority list, meaning thereby that you are senior. Now, one of your junior has been promoted ahead of you. What did he do? You don't do anything.
No, my lord, in that case, my lord, I just give one clarification. Suppose in the event, my lord, if my junior is given promotion by an illegal order of the government, then what happens? The moment it is detected, even if I files an RI application for my promotion, then they, even if there is no post, my lord, they have to create a supernumerary post, my lord, and then give me the promotion and maintain my seniority. My lord, RK Sethi versus
No, I'm not on that.
N1JC, my lord, that's 19.
See, all of you are in the post of SK.
Yes, my lord.
An accepted position is that you are senior to the petitioner.
Yes, my lord. That,
But out of the blues, he has been given out of turn promotion.
correct, my lord. Now, therefore,
You did not raise any objection to that
no, my lord.
in the year 2016.
Respectfully, we did not, my lord. So therefore, my lord, these gross irregularities was detected in 2023, and that is what page 167. The reason is explicitly given there, my lord. And I think
No, only thing is that that is belatedly discovered. Had it not been the case where the post of DLRSO has to be filled up, this problem would not have come up.
correct, but that's why
Only as and when it came up that one DLRSO post is vacant, some posts are vacant. So who are the contenders? Petitioner became one of the contender. You also became the contenders. 15 years. He's got 5 years. He's got 7 years. He requires 5 years. So then this was discovered by the review DPC. And that was in the year 2023. Whereas the promotion, he stole a march over you in 2016, despite being junior to you. So the only question is that why didn't you make any objection at that time?
My case was considered. No considered.
Yeah.
नहीं, दोनों considered. Petitioner को consider किया, हम लोग को भी consider. Petitioner is
in my case, my lord, there is slight, just point out that. Just point out that particular piece. But in this case, his case was also considered, and I was kept number 2. That is the correct fact, my lord.
Where? In 2016?
Just point out.
No, madam, no. In 2023, in the DPC held in 2022, my lord, I was placed as first DPC. I was placed as serial number 1, and
correct.
Respond number 4 was in serial number 2, my lord.
In DPC 2022?
Yes, 22. And thereafter 23, turned down, review DPC.
For what? DPC for what?
DLRSO, my lord. DLRSO, District Land Revenue.
No, that is not what I'm questioning.
But that's right, man. He's not answering that to that point. ASO, then my lord is pointing out on ASO, my lord. They have no, they have not objected.
See, because all of you are SKs.
Yes.
You know who is who.
Yes.
You know your colleagues. Like you're in the bar. You know your colleagues. How much standing he has got in the bar, how many years, you know. Now, out of the blue, somebody, right, in the junior, he's been given a promotion to that post. They're also double promotion.
My lord will have this piece.
Then, didn't you say that, what is this? He never raised any objection.
At that point of time, we have no laws. For the ASO, my lord, only the surveyor eligible, my lord. We are not.
Okay.
We are not eligible, my lord. For the promotion to ASO, my lord, Peter is.
Petitioner is not also surveyor.
No, but in.
Petitioner is also not surveyor.
Yes, my lord. That's why, but suppose.
So why did you keep quiet?
No, at that point of time, I believe, my lord, we have no locus standi to challenge that, my lord, because the recruitment rules say, my lord, ASOs to be promoted on the Peter surveyor, my lord.
No, we know that. Surveyor is there. Nobody has raised that surveyor thing. He has got his double promotion.
Yes, that's why we did not. Yes, we have no local assembly, my lord, and at that point of time, my lord.
You have no locus standi. But the thing is that the petitioner, who also does not have a locus standi, has been promoted.
Yes.
Then is it not natural that you should ask, sorry, what has happened? Why this person who is junior to us has gone there? One objection or one representation is not there, isn't it?
Representations, right.
So that's why I'm asking you, why you all kept quiet? Only when the review was made by the government, then you opened your eyes. Oh.
There's one aspect, my lord. This kindly take cognizance of page 145.
145.
of the read petition.
22 May.
2022 DPC, Milord. Type copy is at page 145, Milord. I'll request my lord to flip to page 146, serial number 10. DPC, may I?
Yes.
DPC has perused all relevant documents as to record placed before it and found the following officers fit for promotion in order of merit. So and so.
Promotion to which post?
DLR SO.
Dealer SO.
And here I am, Milord, respondent number 4.
4 is there, no doubt. Then?
Well, only to this aspect, Milord. Just I want to clarify that my case was also recommended. But in the review DPC, Milord, his promotion was reviewed.
No, these things are okay, I understand. Only my query was regarding 2016. Nobody raised the question.
Perfectly not, Milord.
What has happened? How come this person has gone ahead of us? He's junior to us. That question was not raised.
And
so that's why
yes, and the concluding part that I want to submit is that even for in case of illegal appointment, Milord, here they have not invoked the writ of quo warranto. So therefore, the prayer number 4 and 5 goes accordingly.
Okay.
You have your own time. Take it easy, breathe freely. Because life is too short, you enjoy it. That's accept this, Milord. He has challenged it, page 46, Milord. Page 46 of the read petition. I'm summing up, Milord.
46.
46 of the read petition. His prayer, Milord.
Yes.
5 and 6. Read in the nature of certiorari or appropriate read shall not be issued for setting aside and causing of illegal appointment. This is not correct. The reads, this prayer cannot be considered, number 1. Number 6, Milord. Read in nature of certiorari or appropriate read shall not be issued for setting aside and causing of illegal regularization. This also will not. This is bar by delay and laches, Milord. These 2 prayers, Milord, cannot be considered. If at all, if he is so aggrieved, let there be a writ of quo warranto. Why a person usurping a post is holding that office? You are answerable. Definitely not by this writ.
Okay.
Yes, I'm grateful, Milord.
Step Prime?
Yes.
Yes, sir. My lord, it has.
You have already given a running start of your argument.
Yes, my lord. Just my lord argument is just to in addition of the landed additional age and other respondent, my lord. My lord.
Well, just
Just addition only, my lord. Argument, my lord. Now, for my convenience, my lord, I also divide the case of petition into 2 issues, my lord. First, my lord, he is challenging our initial appointment, my lord, 2004, my lord. Second, about the review DPC, my lord. So, first point, my lord, is the about our challenge being made to our initial appointment, my lord. For that, my lord, I say, my lord, this challenge, my lord, is based in law for 3 count, my lord. 1, delay and lacy, my lord. Other, my lord, the absence of locus standi, my lord. And third, my lord, due to non-joiner of necessary party, my lord. Now, as a delay and lacy, my lord, has already addressed by the land's additional AG, my lord. I will not address on that, my lord. I directly start with locus standi, my lord. His locus standi to challenge our initial appointment, my lord. For that, my lord, kindly for a open, my lord, we turn to page number 56, my lord. Now, when we were appointed, my lord, rule governing, my lord, governing was the post was, my lord, recruitment rule for the post of Surveyor Konga SK is 1986, my lord. Now, my lord will kindly turn to page number 56, my lord.
Hmm.
At last column, my lord, essential requirement, my lord. The requirement, my lord, will see matriculation with record course pass, my lord. Not only matriculation is record course, my lord. Now, to this extent, my lord, in my epidemic in opposition, my lord, I have made a categorical statement, my lord. At that point of time, you are not eligible, my lord. Now, you will not come under the definition of aggrieved party, my lord. In absence of you being the aggrieved party, my lord, you have no locus standi to challenge our appointment, my lord. Now, to that extent, he has replied, my lord. In his reply, my lord, he has some annex class 12 and BA pass certificate, my lord. But he did not annex any record course certificate, my lord. Now, my statement that he has no record course certificate, my lord, that is admitted fake, my lord. Now, if in absence of that, the fake, my lord, he is not the aggrieved party, my lord, to our appointment, my lord. When he is not the aggrieved party, my lord, the read in the service matter, my lord, PIL.
Why according to you is not the aggrieved party?
Because, my lord, he has only degree, my lord. The requirement is matriculation with record course, my lord. With there should be a under certificate, my lord.
Degree comes after matriculation only.
No, degree, no, my lord. Here at that point of
You
time,
cannot go directly to degree. First, you have to pass the matric.
yes, matriculation he has, my lord. He has, my lord.
He has.
But the requirement is with record course, my lord.
Recorder course he doesn't have.
He doesn't have, my lord.
He's got some qualification, I think, special some course.
Yes, my lord. That was after, my lord, 2000, after 2009, my lord.
After 2009.
2002, he has not, my lord. 2004, my lord. 2004, my lord.
No, he was not there in the service also in 2004. He came in service in 2009.
Nine, my lord. And he got in, I believe, in 11 or 12, my lord. The record course certificate, my lord. 11 or 12, my lord. Now, when we are appointed, undisputedly, he has no record course certificate, my lord. In view of that, my lord, he did not come under the definition of aggrieved party, my lord. When he is not aggrieved party, my lord, law is settled, my lord. Any form of PIL, my lord, cannot be maintained in service law, service jurisprudence, my lord. He should be a aggrieved party, my lord, to challenge the appointment, my lord. That is a settled law, my lord. To support that, my lord, as particular purpose, I rely on this judgment of division bench judgment, my lord.
Which case?
This is, my lord, 2006 Port GLT 503, my lord. The relevant para will be 7, 8, and 10, my lord. May I read, my lord?
Yes, please.
7, my lord. The order of appointment of a person against a post can be challenged by a person who claim appointment against the said post. A person who is not qualified to be appointed and who did not apply for post cannot challenge the appointment of any person against the said post. The person who challenges an order of appointment of another person by filing a writ petition must therefore be a aggrieved person aggrieved by such appointment. 8, my lord. A person can be said to be aggrieved person aggrieved by the action of government in appointing another person in the post if that action deprives that person his right to consider for the appointment against said post. The petitioner to maintain a writ challenging the appointment of another person must show that the legal right of there has been violated by action of respondent in making such appointment. A person aggrieved is a person who has genuine grievance against an order which has prejudicially affected his right and interest. A person who is not directly or immediately affected by order of appointment but remotely affected, or he is sons of promotion. My lord, kind of this note also, my lord. A person is not a person who is not directly and immediately affected by order of appointment but remotely affected, or my lord, or his sons of promotion in future has been affected by such appointment cannot maintain this challenging the appointment of other person, my lord. Now, this, my lord, I'm taking pause, my lord, and indicating this. This is the reason, my lord, we did not agitate in the 2016, my lord, because law is settled, my lord. Even we can, until I am an aggrieved person, my lord, that in future my appointment.
This argument you're developing after my question.
No, my lord, that I'm.
It is not there in your pleadings, I think. that we did not raise this issue in that 11
And
time.
yes, my lord, that is not there, my lord.
It is not there. That's why you don't
That
go here and there.
cannot maintain a writ.
The point which you're pressing, this is a basic principle. Everybody knows this.
Yeah, my lord. That's why, my lord.
First of all, you say that this appointment is illegal. That is not sufficient. You are to say that this point is illegal, appointment is illegal, and I'm entitled to appointment. Instead of him, I should be appointed. Then only some remedy can be availed by the person. Because like you already said, there is no PIL in service matter. Anybody appointed here and there, you cannot just say that his thing should be.
My lord, now he
unless of course you avail of the writ of quo warranto.
My lord.
Saying that under what authority has this person been appointed? That's a different matter. If not, you see, you cannot. Court is not there just to disturb all the illegalities.
Yes, my lord.
The person who comes has to say that I am entitled to. He is not entitled.
No, my lord.
He is not qualified. I am qualified. Then you may get the remedy. You may get the relief.
Therefore, my
So
lord.
that's what you're saying here.
Yes, my lord.
At that relevant point of time in 2005 or 6, he was not even qualified and he was not even in the service.
Yes, my lord.
So who is he to challenge our appointment?
My lord.
We are already in service.
My lord.
He was not in service.
Yes, my lord. Now, second, my lord, my lord will delay, my lord, learned ages address, my lord. Now, second, my lord, locus standi. Third, my lord, non-joiner of necessary party, my lord. For that, my lord, to start that argument, my lord will kindly have a look at this.
Who have not been implemented, according to you, non-joiner?
Non-joiner, my lord will kindly, my lord, he is praying for setting aside of my lord order that this is ordered dated 19/1/2005, my lord, whereby our appointment was regularized, my lord.
62.
The page number 63,
No, come to the point, you said non-joiner.
Non-joiner, my lord.
Non-joiner means that party who should have been implemented.
Yes, my lord. Yes, my lord.
Who is that party?
At page number 63, my lord, by this appointment, as much as total 8% appointed, my lord, including 2 of us, my lord. Now, if from the record itself, my lord, we were appointed by same mode on similar circumstances, my lord.
Okay.
Now, if so, my lord, read being, my lord, read jurisdiction being, my lord, discretionary and equitable jurisdiction, my lord, cannot be invoked selectively against two of us only, my lord. Only against 2, my lord. Now, if it's said to interfere with this honorable court by evoking read jurisdiction, my lord, jurisdiction, that in toto, my lord.
Okay.
Now, if that is to be toto, my lord, this person, my lord, other 6%, my lord, as necessary part in this case, my lord.
Okay.
Now, my lord, similar circumstances, my lord, of date of episetting same, my lord, and date of regulation same, my lord. Now, how can the read equitable jurisdiction, my lord, can be evoked selectively against 2% only, my lord? This being a matter of record, my lord, by 6%. So, I believe, my lord, this order cannot be interfere, my lord, particularly in the read jurisdiction, equitable jurisdiction, selectively against us, my lord.
What is that page you're turning to? Page number?
63, my lord. Type out is 63, my lord.
63.
My lord. My lord, you kindly see, my lord, at column 3, my lord, date of officiating appointment. Either 210 3, my lord. Similarly situated, my lord. Other 6%, my lord. We are, I'm at 4, my lord. Responding number 483, my lord. Similarly situated 8%, my lord. Now he is praying for setting it at this order, my lord. Now, if that is so, my lord, this for other 6% also a necessary party, my lord. And in absence of necessary party being a party in the case, my lord, that is always pertained to the writ petition person, writ proceeding, my lord. That extent I have some judgment, my lord. As I am raising that question on also in the review, my lord, I will relay that later on, my lord.
You have filed an affidavit?
Yes, my lord.
Okay.
Now, that the past issue, my lord. For the second issue, my lord, DPC, my lord, to address that issue, my lord, is the before starting addressing that issue, my lord, I will kindly invite attention of my lord at page number 95, my lord, of the writ petition, my lord. So it is page number 90. Sorry, my lord. Yes, 96, my lord. 96. Oh, my lord, I believe that my lord had already seen this, my lord. He, it provisional seniority list, he was at 21, my lord.
That we have
20, my lord.
seen.
Now, thereafter, my lord, will kindly have a look at page number 168, my lord.
This is also provisional seniority list. So 168.
168, my lord.
DPC.
So,
the review DPC.
No, this reported, my lord, 160.
168 is review DPC.
Correct. Sorry, my lord. It is 151, my lord. 151. 151, my lord. 151, my lord. 151. May I read this, my lord? Meeting notice. A departmental promotion committee comprised of the following officers will sit on 23/6 noon in office chamber of secretary to second floor, room number 2, civil secretary Itanagar, to review, my lord, the promotion of Sri such and such from SK to post of ASO and to consider the post of 2 posts of DLRSO under land management. Well, I am indicating this, my lord, because my lord has see 2 minute of meeting, my lord. Now, minute of meeting was this was held concurrently, my lord. It note that one was held earlier and second was held and second point of time. It was held concurrently before those pay were before the DPC in concurrently, my lord. Now, therefore, my lord, we'll see, my lord, some my lord had one question at point of 3 also, my lord. Earlier, one DPC minded, my lord. That was something like discrimination in the DPC. Because, my lord, at same time, my lord, this same, my lord, similar this DPC for this all the record relevant for this DPC for lay before the DPC board, my lord. According to my lord, it is not that case his denial of promotion was held earlier on review his revert to the ASO was later on, my lord. It is a situation where the DPC was sit at the concurrent and same time, my lord. So therefore, those my lord. So therefore, my lord, in the my lord received 2, my lord. So he have annexed his reversion letter in later page, my lord. That was some one can assume that, my lord, this is a later point of time. It was not, my lord. That is concurrent, my lord. So as the DPC, these 2 issues before the same DPC, my lord. Now, once, my lord, his by this at page number, this is minor DPC at page number 168, my lord. Now, and this is type out copy 168, my lord. Point number 2, my lord. On perusal of the draft seniority list, such and such of the senior department that is was found that the officer concerned for promotion was listed at C number 20 and indicate to the petitioner, my lord. There was 20 senior before him. In final seniority list, which was issued on 5/5/2000, it was found that the officer name has been omitted without assigning any reason. The senior most SK above him were found listed in the final seniority list as per proposed draft paper to earlier, my lord. Now, this is the reason, my lord, is once this, when the DPC for this promotion to DLRSO, my lord, was said, my lord, it has found that his initial promotion as ASOs were illegal, my lord. Accordingly, that was withdrawn, my lord. Now, therefore, my lord, I believe if this, assuming my lord, his prayers allow, my lord. Now, assuming my lord aside this order, my lord. Now, my lord will see, my lord, by this DPC, my lord, the seniority of other this 20%, my lord. Senior to my lord, him will be surely affected, my lord. Once my lord will interfere this, my lord, this my lord, DPC, my lord. As by this DPC, he has been reverted back to his seniority as a SK21, serial number 21. Now, if my lord intervene, set aside this, my lord, minute, my lord, he will again jump over those 20%, my lord. Now, if
He has already jumped over you in 2016.
yes, my lord, that had been.
So what difference will it make now? Same thing.
No, my lord, that has been restored by the competent authority, my lord.
No, that has been restored after so many years.
Yes, my lord.
So that's why my question was, after all these years, nobody said anything about it. Until only in 2023, it was suddenly discovered when the post of, in the year 2023, of course. So why this has happened, I'm saying.
Yes, my lord.
Because now after you getting the handle, that review DPC has said, now you are.
No, we are not, my lord. We are not, my lord. My lord is kindly, we have not agitated. It is the authority, my lord. I believe who is competent, my lord, who has authority made their correction, my lord, has reviewed, my lord.
Correct. Authority has done that in 2023.
23, my lord. Now,
which you are supporting now.
Yes, my lord.
Although you never said anything in 2016.
My lord. Now, therefore, my lord, as my lord, the competent authority has restored seniority of other 20%, other 18% or 12, I believe it is 12, my lord. 12% who are necessary party in this case, my lord. Because if my lord interfere this review, my lord, ultimately the seniority restored by this DPC will be surely interfere, my lord. Now, in such a situation, my lord, they are
of course, if the court interferes, it will be disturbed.
Yes, my lord. Then
if you don't interfere, it will not be disturbed.
Now, therefore, if they
that is known.
Therefore, my lord, they are the necessary party, my lord. Therefore, they are the necessary party, and they are not a party in this case, my lord. Therefore, this is fatal, my lord. To that extent, I am relying on this, my lord.
Non-general parties.
My lord. This particular judgment, my lord, this is 2012, my lord, 2012 7 as a 16, my lord. Para 19 and 20 is irrelevant for delay and lacy, my lord. I am not reading as this has been addressed by the learned additional regime, my lord. I'll only read para 28, 29, 30, my lord, for non-joint item necessary party, my lord. May I 28, my lord? 28, my lord.
Yes.
Another aspect need to be highlighted. Neither before the tribunal nor before the High Court. Provincing and other areas of party, there is no dispute about the spectrum that they are senior to the applicant and has been conferred the benefit promotion to have. In their absence, any decision is issue. In their absence, if any direction is issue for fixation of seniority, that is like to jeopardize their interest. When they have not been implicated as a party, such a relief is difficult to grant. In this context, we may refer with the forfeit of the two registration of in the has been held as under. There is another aspect of the matter. The applicant hearing were not joined a party in the petition filed by the respondent. In their absence, the High Court would not have determined the question of interest seniority, my lord. 29, my lord. In Public Service Commission, Uttaranchal versus Mamta Bis and others, my lord. 2000, this is AR 2010 SCC 630. This court, while dealing with the concept of necessary party and the effect of implement of such a party in the matter when selection is observed, thus. I'm skipping the.
All right, Mr. Perme.
Yes, my lord.
I think.
So I'm saying, my lord.
I've understood.
Yeah, my lord. This is fatal, my lord, because they are for non-general necessary party, my lord. Now, therefore, my humble submission, my lord, Yes, my lord, and see, my lord, a person only agree, my lord, who can challenge the appointment, my lord. Even, my lord, if chance of promotion will on the writ petition can be maintained only on the ground that my chance of promotion will be affected, my lord. And that the reason, my lord, in 2016, my lord, as the service recruitment rule say for the ASO is surveyed, my lord. We as a SK, my lord, could not challenge his illegal appointment ASO, my lord.
Okay.
Just one clarification to your lordship's query. Why review after 7 years, my lord? To that point, my lord, earlier I have already made my submission that it is a continuing illegality which the petitioner is enjoying. Now, and that continuing illegality is still continuing the harm to his seniors, the private respondents and others. That is first my explanation, my lord. The second thing is that there is no provision, there is no law barring the government to conduct, there is no law anywhere barring the government to correct its mistake by way of a review DPC. There is no law. Now, in absence of any prohibition under any law to conduct DPC, even after a distant point of time, my lord, I believe the government will always have the power to rectify itself. That is my second submission, my lord. My lord has seen that instances of DPC recommendations being challenged in this honorable court. And even when, after several years of litigation, the honorable courts also sometimes gives a direction for holding review DPC to take into consideration these aspects and conduct a review DPC, where persons who were supposed to have been considered were not considered. In those occasions also, after very long period of time, review DPCs are conducted. So, I'm just giving an example. Now, DPC is being challenged, and the litigation is continuing, and litigation has gone up to 10 years. In the meantime, during the pendency, before the final decision of the honorable court, if the government themselves relooks into the matter and decides to hold a review DPC, seeing yes, what the challenge made against that DPC is their genuine grounds. So motto, if the government takes a decision to hold a review meeting, will that be barred? That also, if it is after a distant point of time, after several years also. But therefore, my respectful submission is that when there is no specific bar under any law or time bar under any law to have a review DPC, when the government has the power to issue, the power to review also, to correct its decision. And of course, I also have concern for the petitioner who was enjoying 7 years uninterruptedly without any objection by the private respondents who are supposed to be his seniors. Now, after enjoying this, whether it will be prudent for the government also to reward him, take his all service benefits away. But that, I believe the government also will have to look into, although the DPC has taken a decision, but he will obviously be given a chance to show cause why, and if have to be taken into consideration. there cannot be some drastic steps against the petitioner also. That I also understand, but that is another subsequent thing which that will have to be considered by the government. That ultimate decision has to be taken by the government. Now, therefore, my lord, here in this case, only the two things. When there is no bar there is no limitation to conduct review DPC, no bar. That, to my respectful submission, the government will have to have the liberty to correct its mistakes by doing DPC.
My lord, just short, my lord, it's been, my lord, patiently hearing, my lord, troubling you. My lord, in my respectful submission, my lord, in reply, in affidavit in reply, I have categorically what they have said, my lord. I just mentioned my reply para, my lord, for convenience, my lord. With regard to the affidavit in opposition filed by the contention raised by the state, respondent number 3, my lord. Regarding I have raised the issue that their initial appointment to the entry to the service itself is illegal. They have not justified. Now, having not justified, now they are now coming upon me saying that we can ignore what illegality they have, the private respondent have done, have been committed, illegally appointed, but will not ignore irregularity. If assuming there's a procedural lapse, what they said, only procedural lapses, my lord. Only for procedural lapses, you are reverting me back, and all illegality against the private respondent that has been condoned. That is what the sum and substance their submission. Man. In para 7, my lord, in my affidavit in reply to the state, respondent number 3, my lord, para 7, my lord, I've categorically replied on this point, my lord. That cannot be done. And with regard to the OM, my lord, para 9.2 and 9.3, I have categorized, my lord, on my point of view, I have stated it cannot be done. Now, with regard to the contention raised by them, that there were many people who could be considered for a promotion to the post of ASO. My respectful submission is this fallacious argument. Because record of their own record of the department shows that there was nobody eligible who could hold the post of the ASO at the relevant point of time when I was appointed as a ASO in year 2016.
Why is that? How is that?
My lord, in the file noting itself, my lord, file noting 120 of my page 120.
No, see, irrespective of the noting, we're examining this now.
My lord.
Whatever noting is there, we'll examine.
Yes, yes, man.
No, just a minute. We're examining the issue. Now, if you say that there was nobody eligible, they were also SKs.
SKs, man.
What were you? You were also SK.
My lord, yes.
Were you something else apart from SK?
No, my lord. I'll come to that point, my lord. I'll address that point.
See, they might have missed out that point that there are no other eligible. But you have to be concerned about yourself.
My lord.
Instead of challenging the appointment of the other side, just concentrate on your thing. Just try to convince the court how you should, you have been promoted and how you are eligible and you are qualified to be promoted. Speak on that point. Like, for instance, you say that there were no other eligible persons at the relevant time. This is what the record says.
Yes, man.
What they say? Over and above what they say, we are examining this issue now. So can you tell us on what basis are you saying that you are the most eligible person qualified at that time?
My lord, in their file noting itself, my lord, I have expertise in particular field, my lord, total station, GPS handling, and auto mapping. This part may have record itself they speak, my lord. I'm eligible.
But that is not the rules.
My lord,
Does it say?
that is why, my lord, my appointment initial the promotion was officiating, my lord. It was not regular promotion. I'll come to the point of the officiating promotion as well.
Officiating has been regularized later on.
Yes, later on.
But there's
Now,
no reasoning.
my lord, ultimately, if the post is vacant, my lord, in the administrative exigency, my lord, somebody, that's the authority, they have a power. They can, it cannot be lying vacant and causing the public interest at stake, my lord. So in order to they have justified the reason in file noting itself that this was required and we required to be made somebody who can handle this. Accordingly, I've been given, my lord. This is an officiating appointment. Now, in their affidavit, my lord, they have not brought on record the government affidavit. They have not brought on record that except oral.
According to you, you have been chosen because you have the expertise.
Yes, mal.
Geomapping, you know.
Yes, mal.
That's why.
That's what. As per the government,
Others don't have it.
My lord, yes. Now, because that is only the apart from.
That's what the record says. Also.
The record only that's the record. That's why, my lord. Now only the para 7, 9.2, 9.3 of my affidavit reply, my lord, I clarified that part. And now coming to the reply to the, I'm just recapping this my reply to the affidavit of opposition. But I'm mentioning the para regarding affidavit of reply to the affidavit of opposition of the respondent number 4. Their contention in para 8 is that they are senior and they have been regularized. That is the only, therefore, that is their contention. But in that regard, para 6 of my affidavit reply, I justify my point.
What is that?
Para 6, my lord. Para 6, they have mentioned the judgment of direct recruit cases also, where it said that if the appointment, because I'm coming to my case is their initial entry itself. Now, when initial entry is there, my lord, unless it is been regularized as per the RR, their seniority cannot be taken into account, my lord. And that, my lord, I'll come to that point, my lord. That is why I've clarified that in my para 6 of the reply.
So that's what I'm asking you. What is there in para 6? Just read it.
My lord, only with regard to the.
What is there in para 6? Tell me. Don't argue with yourself. You give the submission.
My lord.
Please sum up. I think I've heard enough.
My lord, just I'll come that part. My lord, only para part, my lord, regarding all those their locus standi and issue, my lord, that has been, my lord, I have categorically replied in the. My lord, the para 6, my lord, I have with regard to the amendment made in para 8 of the affidavit of opposition, your humble deponent beg to retract his statement in para 17 of the writ petition and further beg to state that private respondent 4 and 5 being illegal appointees cannot equated with the position of the petitioner, who is regular appointees and according to the relevant recruitment rule. And as such, they cannot claim any seniority over the regular appointees like the petitioner. Judgment of so and so, my lord, they have quoted, I have justified the distinguished would not be any assistance to the case of private respondent 4 and 5, inasmuch as their seniority cannot be taken into account to supersede the seniority position of the petitioner, as they have not been regularized in accordance with the relevant recruitment rule till today. They have not been done.
All right, but on that, I'll just ask you one question. Against that provisional interstate seniority, did you file any objection? No. Did you file? There were 2 provisional seniority lists.
My lord, that part also, I have in para 9, my lord.
Answer has to be yes or no, that's all. It cannot be here and there.
I have filed objection. I have filed objection, my lord. And accordingly, my lord, that part, my lord, because that has not been acted upon, my lord. Later on in para 9.
Where is your objection? Show me then.
Para 9, my lord.
Your objection, is it annexed to the writ petition?
My lord, regarding.
In 2012, the first provisional seniority list, he did not file any objection. In the second 2015 provisional seniority list, he filed an objection. Yes.
And any final seniority was issued?
Yes. In the final seniority list of 2016, his name did not figure.
Okay, his name.
In the interim, he was.
Oh, he had gone there.
Yes. In that regard, my lord, para 9, my lord,
That explains it.
that explain it, my lord. With regard to the amendment made in para 14, 15 of the affidavit of opposition, your humble deponent begs to state that as on that 02/02/2016, the petitioner has already given promotion to the post of ASO officer on officiating basis, and his officiating promotion was regularized by constituting regular DPC on 29 December 2000.
Yes, yes,
That's
got it.
the regular shown the before. Therefore, the question of challenging seniority list of senior survey staff on dated 05/05/2006 does not arise at all. Furthermore, name of the petitioner was not even in the seniority list of the survey staff published on 05/05/2006, as he was already given promotion to the post of which is higher post to the SK. Hence, the question of seniority, hence the question of challenging the seniority list of the survey staff department on dated 05/05 does not arise at all. My lord, that is with regard to the affidavit, reply to the affidavit of opposition filed by the respondent 4. And with regard to the 5, my lord, there are one of my reply, 1.5, my lord, that regarding the locus standi. I have clarified that in my affidavit, my lord. So far, their appointment, illegal appointment is concerned, my lord. As and when they were appointed, even regularized in 2005, they were not holding even the certificate course, my lord. The survey certificate they are not having. They now that part, my lord, locus standi part, my lord. I'll just skip. Para 1 of my affidavit in opposition of respond number 5 counter. One, my lord. I'll just read, my lord. Reply to the counter affidavit of para respondent 5. With regard to the amendment made in para 5 of the affidavit of opposition, your humble deponent denies the petitioner was not eligible to be appointed as a supervisor in Karnong or so on, so 2005, 2004 to 5 in terms of prevailing recruitment rule. Thus, the allegation leveled by the respondent 5 in this his affidavit alleging that the petitioner was not having requisite qualification of class 12 pass in 2004 to 5 is absolutely false and misleading. According to same as hereby denied, it is pertinent to mention that as per recruitment rule 1986, prescribed education qualification for the post of supervising Kanungo was matriculation. But in the instant case, the petitioner has already passed the class 10 in the 2012 in 2002. And thereafter completed his graduation in 2005. On the contrary, as for the official record of the department, as annexed in Annexure 12 to the writ petition, the educational qualification of private respondent 5 was only class 12 pass as on dated 31 May 2012. Thus, the petitioner has far more qualified than the private respondent 5 in the year 2004 to 5. Hence, it is submitted that when both private respondent 4 and 5 were illegally appointed the post of SK, the petitioner was very much eligible for appointment to the post of supervisor in Karnango in the terms of prevailing recruitment rule. Hence, the petition has locus to challenge in this aspect, madam.
No, why do you say the appointment is illegal? Otherwise,
rule says, my lord. Rule says, 1986 rule says it should be a selection, through competition, my lord. But since they had not been gone through and only on pick and choose basis, that's in violation of.
That is the reason.
Yeah, that is the only reason.
Pick and choose, no selection.
Yes, my lord.
Okay, now you were just reading the qualification of yourself and the qualification of the others.
Yes, sir.
But one thing which you have not mentioned anywhere is regarding whether you have the recorder course or not.
Yes, madam. I have.
They have the recorder course? Or you have the recorder course?
They have, when they were appointed, even regularized, they were not having requisite that course, madam. In the page, my lord, 184, my lord. 182, 84, my lord, that's a record showing that I have complete, my lord. This is my, They have government. They have sent the government after my appointment.
After your appointment.
Yes,
But
2011.
But the rule says that essentially is that matriculate with recorder's course.
My lord,
It doesn't say that
no.
you'll be sent for training after you are appointed.
But they were not having my lord. And I was through recruitment, through selection process, through but under latest 2008, my lord, 2008.
2009, when he was appointed, he also did not have the geomapping certification. He doesn't have. And
So,
then subsequently,
so that's it. Both parties need not have.
My
Subsequently, you all had that training.
we don't have
So can you point finger like that?
aspiration on us. Verify the fact and then make the statement.
My lord, no, they private respondent 5 has obtained only after the appointment, after the revision. That is
So
what I'm saying. They were not having.
Ultimately, we
Now-
will end up digging up everything. Eh?
Now, my lord, in respect of this latest recruitment rule, my lord, under recruitment rule, of course, there's no specific, my lord, that regarding the course certificate course, my lord, for mapping and. But after appointment, we have been sent by the department. I have been sent.
There's no dispute about you being sent or not acquired.
No.
My only question was whether you have that qualification on the date of your consideration.
Yes, my lord.
Being appointed.
Yes, my lord.
Then why,
2011.
then why didn't you read in your reply affidavit that you are a graduate with the recorder's course?
My lord, in
that statement is missing.
Yes, 2000, my lord, 2004 and 5, my lord. That is, my lord. So for educational qualification, he has raised the educational qualification. I replied that education qualification, my lord.
No, that's why when you are saying that they are not qualified, they are backdoor entry, they are pick and choose. You are at the same time supposed to say that whereas for me, I am selected as per the due procedure and I'm duly qualified and I qualify as per the recruitment rules.
My lord,
which you have avoided.
Yes.
So meaning thereby that there is something.
No. In the
and you at the same time you say that you have the training, you have been sent for
yes,
training.
in affidavit, my lord,
After your appointment.
My read petition, madam, I have categorically, I have reiterated that part also, and that is my additional submission, reply to their allegation, my lord. Now, my lord, just that is all aspect of the just reply on their aspect. Now, my lord, coming to the legal issue they have raised regarding, my lord, delay and latches, my lord. I'm coming to that point now, my lord. Delay and latches, whether in this case, whether they can take the defense of delay and latches or not, my lord. Because my contention in this case is challenge is their illegal appointment, my lord. Their initial appointment is I'm challenging, my lord. In such scenario of the case,
whether they challenging their appointment,
my lord.
You are also coming out now in 2000.
My lord, that's why, my lord.
2023, challenging their appointment in 2004, 5, 6, like that.
My lord.
Why don't you challenge as soon as you enter the service?
My lord, just
I'll dig things like that. You see,
I'll
no end.
I'll just
there'll be no end.
My lord, I may be allowed to clarify this point.
Which point?
My lord.
Which point? You're trying to justify the delay in latches, which has been alleged against you by saying that they themselves.
In my respectful submission, my lord, I'll just try to stand that they cannot take up defense of the delay and latches in these such cases. When I challenge their appointment.
Why?
My lord, I'll come to that point.
Why? Because their appointment is illegal.
Yes, my lord. I'll also, my lord.
No, you just sum up. You see, everything is there.
My lord, I'll just
your pleadings and accordingly take a decision.
My lord, in order to take, my lord,
in order to save time, all right? We have heard you yesterday. First half, I heard you.
My lord, in
so
case
you just have to reply briefly what I have said. That's all.
My lord, in regarding for delay and latches, my lord.
5 minutes. I'm giving you 5 minutes, Mr. Tagum. I have to rise early also.
My lord, just I'll also my yesterday's, my lord, already the compilation I have given, my lord.
I have it here.
My lord, that case number 4, my lord, I relied, my lord. That is, my lord, to claim the defense, to take a defense of the kind of delay and latches, my lord. First, they have to show that their original entry was legal. It is permissible. That is the only thing. My lord, and if it is not there, then the they cannot take that plea, my lord. Now, regarding
In other words, you are saying that if they cannot justify their initial appointment, they should keep quiet.
my lord, that is
And
my
not
lord.
raise about delay latches and all that. This is what you're saying, basically.
My lord, only the.
I'm summing up for you.
My lord, that is, in the face, my lord, now this with this court being my lord, in case delay latches, my lord, it comes within the ambit of principal equity, my lord. Now the question is whether this honorable court, being the court of equity, would apply the principal equity in the case of illegal appointment and ignore such illegality, my lord. In such case, my lord, the honorable Supreme Court, in the my case yesterday, I compilation I've given case number 6, my lord, at para 38 to 40, my lord. It say that no, if it's repeatedly, my lord, it has been relying other principle, other various decision, my lord, held that, my lord, the principle of equality have no role to play in such illegal appointment and cannot ignore such illegality, even if it's they've been working for the last 20 years also. That cannot be taken as a plea, my lord, as being in the as a part of equity, my lord. That is, my lord, that has been said in case number 6 that I have relied, my lord. Now, again, my lord, same as it, my lord. My most relevant part to their argument, my lord, case number 6, my lord, compilation I have given, and also case number 11, my lord. Case number 11, 2010, my lord. In this case, my lord, they have relied other case, my lord, illegal appointees, my lord. In that case, my lord, appointment was made in violation of the recruitment rule, and some also referred to certain case who were served for the 20 years. But court said that no, you cannot take the plea of delay and latches, and it cannot be done since your entry is illegal, my lord. That is altogether there. The what citation they have said, it is absolutely is not relevant. On my understanding, it's not relevant to the present case, my lord. Now, coming to the, my lord, coming to the case of officiating appointment, my lord. Now, in my respectful submission, my lord, an officiating appointment for entry to the post, my lord, that first entry, it cannot be an officiating appointment, my lord. In the present case, initial appointment of respondent 4 and 5, in disguise of officiating appointment is nothing but illegal appointment, my lord. It's for the promotional post and not for initial appointment to the post. The term officiating has been misused in the present in respect of respondent 4 and 5. The circumstances under which the petitioner was given officiating appointment to the post of ASO in the year 2016 is the correct method of giving officiating appointment. I'll just rely this part. There's a decision of the Honorable Supreme Court clarifying what is officiating appointment. Their appointment cannot be treated as officiating. Their appointment is under disguise of officiating. It's illegal appointment, my lord.
Now, what are you looking for?
My lord, regarding that of
judgment.
Yes, my lord. Just regarding officiating appointment, my lord. The officiating appointments always under what circumstances it can be done. It is always for the promotional post, my lord. In my case, my lord, it was a promotional post. My entry is legal, my lord.
Okay.
Para 11, my lord. I've highlighted, my lord. According to its ordinary connotation, the word officiating is generally used when servant having held one post permanently or substantively is appointed to a post in higher rank, but no permanently or substantively, while still retaining his lien on the substantive post. That is officiating in that post till his confirmation. Such officiating appointment may be made when there is a temporary vacancy in the higher post due to death or retirement of the incumbent or otherwise. In contrast, the word ordinary usually denotes the person appointed in the civil service for the first time, and the appointment is not permanent but temporary, for that being no right to the post, my lord. Now, my lord, regarding, my lord, one point, they have also raised, my lord, regarding relaxation and all, my lord. Respondent, they have raised the issue that they have relaxed. There's a provision of relaxation under the RR, my lord. Now, regarding if the initial appointment itself is illegal, my lord, that cannot be relaxed, even if there's a provision under RR, my lord. Even if there's a provision providing that any of the rule can be relaxed, but that doesn't mean that they can do away everything. But only it is a condition, can be service of condition. Once if they enter into legally, then subsequent there it can be relaxed, my lord. My lord, para 2, the para 2, my lord, like, this is similar, my lord. The provision was also in RR, provision was also there for relaxation. Invoking that, my lord, para 2 and 8, my lord. 8 elaborately discussed, my lord, at page, I'll write from 8, and I'll just take, my lord, the para under the 8 only. It's all relevant, my lord. 2 and 1 to talk about the fact and the finding 8 and 494, my lord. Second, third paragraph. I'll just read that, my lord. In the present case also, the appointment of the employees whose service are sought to be regularized where dehorsed the rule. The Rule 14 merely permits relaxation of the provision of RR in a public interest, but in the total serving of the rules. But not as a total serving of the rules. The order do not say that rule or rules the government consider necessary, expedient, and to relax. What has been done under the impugn order is that to regularize illegal entry into the service as if the rule were not in existence. Because besides the reason for so doing are not set out, nor it is clear how such regulation can be serve public interest. Rule 14 has to be strictly construed and proper foundation has to be laid for proper power and the rule. The rule have shown. My lord, this is regarding they have no power, my lord. And in similar case, my lord, my lord, regarding the condition of recruitment, especially initially, it cannot be relaxed, even if there's a provision for a provision in the RR itself. Second, I'm relying, my lord, on same principle, my lord. There it said that the first to get relaxation power provision benefit, first his entry has to be illegal, my lord. Valid. Then only subsequent it can be relaxed. Para 28, 29, para 28, relying the three bench constitution bench. Para 28, 29, and 31, my lord. Now,
Mr. Tagum,
my lord,
you're giving me citations or library?
my lord,
One is enough.
my lord,
You
my lord,
don't
that is my lord. First,
Your compilation also speaks about the same story. You have given me so many.
my lord, regarding relaxation part.
Don't burden the court.
My lord, all right, my lord, regarding my lord, my respectful submission, my lord, they don't have and they cannot claim anything against me, my lord. Now, even in the case of my lord irregular, their case is illegal appointment. Now, in irregular appointment also, my lord, in the Honorable Supreme Court, it's repeatedly be handled. Even it's become the settled principle law that irregularly appointed candidate cannot be allowed to march over the regularly appointed, even if they were appointed prior to the appointment of regular appointees, my lord. That, my lord, I'll just that just I place, my lord. 1987, my lord. I just supplied para 19, my lord. Para 19. If this is regarding the irregular appointment, they were processed, but certain procedure lapses were there in initial. In that case, the Honorable Supreme Court said that no, this irregular and illegal appointment, irregular and regular appointment, they cannot be equated with each other. They have a different classes, and therefore the seniority would be always in favor of the person who has appointed through regular process and not that of the irregular cannot be given priority, my lord, march over, cannot be allowed to march over. This is the case of irregular appointment, my lord. But in case of present case, my lord, they have illegal appointment, they are very standing, they have a no right unless to show, show that they have a right, my lord. That is why my delay and latches also, my lord, that I raised, but
All
this
right.
can be raised, my lord.
So I'll consider
My lord.
all these aspects and pass necessary orders. You give any citation you have, you give. Please write.
My lord, I'm sorry, my lord, in similar case, my lord, the earlier also that SK, my lord, illegal appointment, this honorable court has set aside in court. The same, my lord, this violation of rule.
Heard Mr. T. Tagum, learned counsel for the petitioner. Mr. N. Ratan, learned additional advocate general, appearing for the state respondents. Mr. T. T. Tara, learned counsel, appearing for the respondent number 4. And Mr. L. Permet, learned counsel for the respondent number 5. Hearing concluded, judgment reserved.
Obliged, my lord.
My lord, earlier judgment.
One request, in mind, whether under in exercise of power under 226, whether the Reef Court can treat as appealed authority over the finding of the TPC. I forgot to raise that. I am extremely sorry. And that would be one of the main conditions.
No, court cannot sit as a DPC.
That aspect, because
court cannot take the places of a DPC.
Place of the DPC, correct. That's finding reversing is promotion.
Otherwise, we'll be usurping the role of the DPC.
Absolutely, my lord. And there is no bar for the government to constitute a review DPC also. The law.
Okay. You give this in a separate file, no? You give a filing board and
Yes, sure.
we'll just follow your input.
One more item.
My lord,
Item number 7.
can I submit my, just read.
You write your name also, so that I know that it was you who was submitted. Item number 8, is it?
7.
Oh, 7. Anyone? Yes. You are there. Yes.
My lord,
You don't want me to see the file? Item 7. Where is the file? You take this and put you tie this in one board, this judgment separately. Otherwise, you'll get mixed up. Yes.
may please, ma'am.
Reply is also filed.
Yes, madam.
Not yet filed. Oh, filed.
File.
File.
Okay.
My lord, otherwise, it is ready for my lord, admission hearing, my lord.
See, we'll have this
Subject
matter in some other day, not today.
My lord. I have no
I
issue.
understand that, lordship, but then only that this is eviction matter, and then they have already started the building when they came to this court, lordship.
Started
The
building.
building might have, they might have
My lord,
completed. the
there
building.
is, my lord,
There is an
status quo order. my lord.
status code.
Encroachment. There's an encroachment.
Encroachment, lordship.
Encroachment of government land by construction.
Yes, by construction. In between the quarter, lordship, they have
Okay.
uprooted the fencing, and then in between two quarters, he have started building, lordship.
Okay.
In my affidavit, I have given the lordship.
What was the interim order?
photographs also.
In three,
What is the interim order?
my lord, actually, my building has been sealed, my lord, by this interim order, my lord.
But it has been stayed.
And that has been
That
stayed,
is
and
the state, that's right.
and
lordship.
I have been also directed not to construct. Not to, my lord.
However, it is made clear that no construction shall be carried out by the petitioner over the land.
Yes, my lord.
So we'll fix it up. When do you want it?
Yes, lordship, can it be next week?
Next week?
Because
Well-
status quo order is always there, but then other party never lordship, follow the.
Who are the parties? You are there for the petitioner
Yes, I put.
and you are for the state?
Yes.
And who else? Any other party?
No.
You are, what is for?
Private respondent, my complainant, my lord.
Company?
Complainant, my.
Complainant, okay. You also have filed affidavit? Okay. Please write, parties are represented by the respective councils and they submit that pleadings are complete and the matter may be taken up for admission hearing on a convenient date. As prayed for, let the matter be listed. You want it next week or after that?
My lord, next week if possible, my lord. Otherwise, my lord, after next week.
Okay.
I will be-
List on 18th.
Much obliged.
My lord, interim order may be continued.
Interim order passed earlier shall continue till then.
Obliged.
General Clauses Act. This is from here?
Yes, yes, Lordship.
Okay. You have to give me one copy from the library or something.
Yeah.
Okay.